million and plus lives to this country. The word genocide was first coined by a Polish lawyer in the name of Raphael Lemkin in 1944 in his book, Axis Rule in Occupied Europe. It consists of the Greek prefix genos, meaning race or tribe, and the Latin suffix "cide", meaning killing. Lemkin developed the term partly in response to the Nazi policies of systematic murder of Jewish people during the Holocaust, but also in response to previous instances in history of targeted action aimed at destruction of a particular group of people. Later, Raphael Lemkin led a campaign to have genocide recognized as a codified and an international crime. Genocide was first recognized as a crime under international law in 1946 by the United Nations General Assembly in its resolution 96/1. It was codified as an independent crime in 1948 Convention on the Prevention and Punishment of the Crime of Genocide. As of April 2022, the convention has been ratified by 153 states. Though the above short historical background and codification of the 1994 convention, Rwanda experienced the same kind of crime 3 decades ago. Such a crime was to be followed, obviously, by efforts to deliver justice and prevent that it would occur or happen again as a common responsibility of the entire world. It's now 30 years that it happened again in Rwanda, as I said above, and the question that will be the center of reflection here in this conference is, was justice really delivered 30 years later after the genocide happened in Rwanda? What lessons have we learned? For purpose of reflecting on how far we've gone, both domestically and internationally, in delivering justice, gathering here as people with different responsibility to deliver justice and discussing a topic like 30 years after the 1994 genocide against the Tutsi, insights from international and domestic criminal justice is paramount. In a post-genocide era, truth and reconciliation plays a very important role in building sustainable peace and development. And this happens in any country that has experienced the same. Rwanda has made tremendous progress in upholding the above-mentioned values. Domestically, I can mention the establishment of the Gacaca courts and the work that was and still be done by our domestic courts. I can also mention the establishment of the ICTR by the UN Security Council in its resolution 955 of November 8, 1994. However, regardless of the effort mentioned above, we should not be satisfied with what we have achieved and settled, because a good number of genocide fugitives have not yet been tried or brought to book. Having looked at how our society and our region seems to have not learned lessons in the 1994 genocide against the Tutsi, Rwanda Bar Association and Certa Foundation agreed and decided to co-organize this conference with the aim of having this conversation and adding our voice to the work that is being done to fight denial and any other related offense. Let me conclude by stating that we Rwandans should be proud of how far we've come as a country. The experience of the past 3 decades after the 1994 genocide against the Tutsi should serve as a foundation to promote justice, truth, unity, and reconciliation as pillars that will sustain our gains and achievement of a peaceful and developing society. I believe Rwanda as a society that suffered from a tragic history is our role, and we should give our contribution to make sure that genocide never happen again. Without further ado, I would like to thank each and everyone that attended this conference. And I would also, Honorable Chief Justice and Honorable Minister of Justice, would like to let you know that the speakers and the participants to this conference were selected very keenly, and we wanted to have this conversation, and then so that lawyers can have an idea of what is happening around the globe, but also have an experience of what has happened in the past 3 decades. Speakers have experience in both domestic and international justice, and I believe each and everyone that has sacrificed his day off today in the morning will benefit in one way or the other. I therefore would like to welcome you all to this conference, and thank you once again for having participated in this conference. I wish you a fruitful conference. Thank you.
Thank you so much, Maitre Moses, for the welcome remarks. It is now my honor to invite Dr. Faustin Heziryayo, the Chief Justice of the Republic of Rwanda, for his remarks.
Thank you very much. Honorable Minister of Justice and Attorney General, the representative of the Prosecutor General, the President of the Rwanda Bar Association, Senior Counsel Florida Kabasinga, founder and Executive Director of Certa Foundation, distinguished guests, and may I recognize different former ICTR prosecutors present, ladies and gentlemen. It is an honor to address you today as we gather to reflect on a solemn and a significant milestone, 30 years since the 1994 genocide against the Tutsi. This conference themed 30 years after the 1994 genocide against the Tutsi, insight from international and domestic criminal justice is an opportunity to evaluate the stride we have made in combating impunity, confronting genocide denial, and nurturing justice and reconciliation. The genocide that unfolded in Rwanda 3 decades ago remains one of the darkest chapters in human history. Over 1 million lives were brutally taken, and the scars left on the survivors and the nation are profound. In the aftermath, the pursuit of justice became not only a moral imperative, but a foundational pillar for rebuilding Rwanda and ensuring such atrocities will never happen again. International and domestic criminal justice systems have played pivotal roles in this pursuit. We recognize the establishment of the International Criminal Tribunal for Rwanda ICTR, which marked a significant step towards international accountability. The ICTR had the mandate to try the key perpetrators of the genocide against the Tutsi. For the first time, individuals at the high level of government and military were held accountable for their actions. The ICTR set a crucial precedent in international law, particularly in recognizing rape as a means of perpetrating genocide and emphasizing the responsibility of individuals for crimes against humanity. At the domestic level, one of the foundations of our efforts to combat impunity have been the establishment of a robust domestic justice system. This system is built on the principles of fairness, accountability, and transparency, ensuring that justice is served at all levels of society. In the immediate aftermath of the genocide, Rwanda faced the monumental task of prosecuting a vast number of individuals responsible for heinous crimes. I remember that at the time, we were contemplating of using classical or, the conventional and traditional justice to deal with these cases. We tried to strengthen with significant investment in training and resource to enhance the capacity of the judiciary, but as I said, given the magnitude of the problem to bring to justice thousands of persons suspected of genocide-related cases, and seeing that the conventional and the traditional criminal justice system was inappropriate, massive number of genocide cases. These courts emphasize truth-telling, accountability, a number of cases, and played a crucial role in restoring social cohesion. Talking about social cohesion, I recall this last week when I had the privilege of hosting my colleagues from the Supreme Court of Kenya, and led by the Honorable Chief Justice of Kenya. The question that came too often was, how come? How did you, succeed in restoring social cohesion among the population of Rwanda? This problem or this question is often asked to us, but we have to say that Gacaca did play a crucial role, but of course for Gacaca to come to fruition, it came from the leadership of this country that considered that people had to live together, but we had to take some choice, and one was to make sure that the restoration of social cohesion is a priority of the then government set up in 1994, and it is even up to now the priority of the government. As we commemorate the progress made, we must also acknowledge the ongoing challenges. Genocide, denial, and revisionism remain pervasive threats. These insidious forms of hatred and misinformation undermine the truth and dishonor the memory of the victim. It is then our collective responsibility to combat these narratives with unwavering commitment. Education, documentation, and remembrance are powerful tools in this fight, and they must be employed tirelessly. Moreover, the fight against impunity must continue. There are still perpetrators at large, and it is imperative that international cooperation is strengthened to bring them to justice. The principle of universal jurisdiction must be upheld, ensuring that those responsible for genocide can find no safe haven. I am very pleased to note, as I said in starting my remarks, that in this gathering, in this conference, as also the President of Rwanda Bar Association said, very eminent personality has been invited, and we will be, of course, keenly waiting to hear from them so that we can continue to advance as far as international justice is concerned. Moreover, we continue also to reflect on the domestic status of criminal justice. We must recognize the strides Rwanda has made in building a resilient and inclusive justice system. We note with pleasure the setting up of various institutions, such as the National Unity and Reconciliation Commission, whose activities, as we know, in Rwanda has been taken up by the Ministry of National Unity. The setting up of institutions such as Kwibuka, such as the Association of Student Genocide Survivors, IRG, that have been established to foster dialogue, hearing, and social cohesion. But also the continuous reform in the judicial. All these demonstrate Rwanda's commitment to justice and peaceful coexistence of its people. These efforts have been instrumental in fostering a sense of justice and healing among survivors and the broader community. However, as we know, justice is not a static achievement. It is an ongoing process. As we move forward, we must continue to strengthen our legal frameworks, enhance the capacity of our institutions, and ensure that justice is a humanitarian one. It requires the collective efforts of governments, international organizations, civil society, and individuals. As we gather in this conference to share insight, experiences, and strategies, let us reaffirm our commitment to justice, truth, equality, and peaceful coexistence of people. May our discussions inspire renewed vigor in our collective efforts to ensure that the horrors of the past are never prevail for all. Thank you very much for your kind attention, and I wish you a fruitful deliberation. Thank you very much.
Another round of applause to appreciate the Honorable Chief Justice. Thank you so much for your deep insights and for taking us through a kind of reflection on the work done around the issues of justice after the 1994 genocide. It is now my honor to invite Ms. Florida Kabasinga, the founder and executive director of Certa Foundation, to address us on the launch of Certa Foundation's Kwibuka special issue.
Honorable Chief Justice, Honorable Minister of Justice and Attorney General of the Republic of Rwanda, the Prosecutor General's representative, Honorable Inspector General of the National Public Prosecution Authority, Honorable President of the Rwanda Bar Association and Chair, Certa Foundation Board, Certa Foundation board members here present, Ms. Evita and Bonnie and others who are not here. We have various board members who are in town, but some of them are actually helping us conduct trainings in IP at the moment, so they are not here. Colleagues from the legal fraternity, partners of the foundation, dear friends and colleagues, council members of the Rwanda Bar Association, good morning. I am very humbled that this day has come. At the foundation, which is a think tank that aims to contribute from the private sector to the development goals of our country, we felt a profound sense of duty to contribute to the discourse around the Kwibuka 30. In this regard, we partnered with the Rwanda Bar Association to have these conversations today. I would like to thank all the participants who have chosen to attend this conference on a public holiday. For every day, we must renew our commitment to never forget what happened in this country. We must teach future generations that if we forget, we risk making the same tragic mistake that past generations have made. In addition to this conference, the foundation has chosen to shoot a documentary and publish a journal in commemoration of Kwibuka 30. With regard to the journal, we are finalizing a special issue that has attracted contributions from Rwandans and non-Rwandans. It will be launched on a webinar on the 25th of June 2024. And we invite all of you to be part of this webinar to hear from the contributors and what they have written about the genocide that happened in this country. As we commemorate the 30th anniversary of the 1994 genocide against the Tutsi, it is with a profound sense of reflection that I introduce this special issue of Certa Foundation's journal. This journal, carefully organized by the Center for Law and Innovation's Research and Knowledge Development team, serves as a quarterly scholarly beacon illuminating the evolving meaning, remembrance, embodied and just genocide and reconciliation in other contexts. As the Executive Director of Certa Foundation, I am immensely proud of the collaborative effort to enrich our understanding, but also honor the legacy of those who perished and celebrate the resilience of those who survived. Among the contributions, we have divided them into 4 parts, Tutsi in Rwanda. I'm extremely proud of these young Rwandans that have contributed to this journal because we must pass on this mantle to the next generation, and they're doing an exceptional job in what they've done for this journal. The 4th contribution is from another young lady who's Rwandan, Kajina Laura Jeanne d'Arc, titled The Genocidal Rape in the 1994 Genocide Against the Tutsi, a tool of terror and the enduring legacy of impunity. The 3rd part of this journal is Rebuilding a Nation, Justice, Reconciliation, Peace Building, and Identity in Post-Genocide Rwanda. The first contributor is Dr. Alphonse Murefu. His article is titled, 2 of our colleagues for the first time are actually writing about their personal experiences. They were very young children at the time. One of them is Daniel Ndaishimie and Benita Uruhisho. In bringing to life this journal, we have actually involved very young people to do the editing, to go through the work, to do the research. And among them, we have both Rwanda and hope will take this mantle on for the next generations. I take this opportunity to thank our partner, Rwanda Bar Association, and in particular the President of the Bar Association and my fellow council members for the support. I would also like to recognize Events Factory that have been an unwavering partner in this conference. The work we do at the foundation to train the next generation of legal practitioners in this country, we don't do it alone at the foundation. We have support from senior lawyers who come in to train the young lawyers for free. We have support from different public institutions, that in fact bring on these young lawyers newly minted from universities to come and train them and mentor them. In this regard, I would like to recognize the Chief Justice and the Judiciary, the Ministry of Justice, the National Public Prosecution Authority, and others that actually accept these young lawyers to be trained by them. It is my fundamental belief that in private sector, in the private practice, yes, we get to train young lawyers, but in fact, in public sectors is where much of the work and learning can be done very quickly. So I'm grateful to all the partners that work with us. With those few remarks, allow me to introduce you to the next speaker who was unfortunately unable to join us physically because today is a Muslim holiday. Justice Hassan Boubacar Jallo, current Chief Justice of the Republic of the Gambia and former Chief Prosecutor at the ICTR, has graciously sent us a video of his remarks in commemoration of international justice and its impact on post-conflict Rwanda. I am grateful for his generosity in taking time to send us this message. Thank you so much for listening to my remarks.
Honorable Chief Justice of Rwanda, Honorable Minister of Justice and Attorney General of Rwanda, Honorable Prosecutor General of Rwanda, Honorable President of the Rwanda Bar Association, Honorable Founder and Executive Director of the Certa, distinguished guests, I feel greatly honored to have been invited to deliver the keynote address at this Kwibuka conference on the 1994 genocide against the Tutsis. It is a matter of regret for me that I am unable, by reason of giving so much of their time and their energy to the cause of justice and accountability in Rwanda and elsewhere. Their participation in this conference will, I am sure, greatly enrich the discussions on this very important theme. I salute you all, distinguished guests. I salute the people of this beautiful land of 1,000 hills, my home from home, a land which under a visionary leadership has catapulted itself from the depth of misery of genocide into the front line of the 21st century and become a model of governance, of development, of justice, and of reconciliation. Some 3 decades ago, the world witnessed, and I mean literally witnessed, for it stood by and watched, the unfolding over 100 days of the greatest humanitarian tragedy of modern times. 1994 was a very bad time for Rwanda, but it was a very bad time too for the rest of humanity. For both at the domestic level in Rwanda and at the global level, the principle of good neighborliness and responsibility it is necessary to continue to reflect on that great tragedy, to reflect on the Resolution 955 of 1994, adopted on 8 November 1994 to establish the ICTR, clearly had some of these elements in mind. In the preamble to the resolution, the Security Council, among other things, determined that the situation in Rwanda in 1994 constituted a threat to international peace and security, thus providing the Charter mandate for Security Council intervention. It affirmed Council's determination to end the crimes being committed in Rwanda and to take effective measures to bring to justice the persons responsible for them. It expressed its conviction that these measures would contribute to the process of national reconciliation and to the maintenance of peace. In sum, the Security Council decision to establish the tribunal was motivated by the need to halt the crimes. It must be acknowledged, however, upfront, that the halting of the genocide against the Tutsis and the restoration of peace thereafter was not the achievement of the UN or of the global community. It is also worth noting that the statute of the ICTR, which is an annex to the UN Security Council Resolution 955, does not persons allegedly responsible for the crimes. This does not necessarily mean, of course, that the statute is divorced from. To begin with, the arrest and transfer and trial in Arusha, Tanzania, of the leaders of the genocide, ranging from the Prime Minister and Head of Government, Jean Kambanda, to cabinet ministers, military leaders, heads of the ruling MRM-ND party, media practitioners who pre-genocide, local government administrators, Interahamwe militia leaders, all of whom had fled from Rwanda, removed from circulation almost the entire top echelon of the genocide, and no matter how painful the events in issue. I consider this deference to the law by survivors in Rwanda, even culminating in the abolition of the death penalty against the perpetrators of genocide and mass murder, to be a remarkable gesture of reconciliation. The process of international criminal justice, it seems, may have had some influence on international criminal justice was not directly concerned with peace and reconciliation as an objective, focusing on the narrow. Some aspects of this justice process nevertheless have, in my view, contributed to these broader objectives. The arrest program was clearly versus Karamera and another. By holding further proof, it slammed the door on genocide denial and revisionism. It established the most fundamental truth of 1994, that is binding on the global community, the truth that from other countries, which has since then enjoyed global recognition as a jurisdiction of respect for the rule of law. The task of ensuring accountability for the genocide against the Tutsis was not exclusive to international justice systems. Many other countries have shared the burden, providing support to the tribunal, to Rwanda, and in some instances undertaking prosecutions themselves pursuant to the universal jurisdiction principle, and concluding more genocide cases than any other jurisdiction, national or international. And in a way that is unlike the other systems, more directly concerned with and committed to reconciliation as an objective of the judicial process. In doing so, Rwanda has recognized the value of and resorted to the use of our traditional African dispute resolution mechanisms in the form of its own gacaca courts of situations, the positive role of our traditional mechanisms in favor of what are regarded as conventional court systems. We must not abandon such traditional courts. We need to strengthen them, and we need to retain them as important agents for justice in its broadest sense. We have tried to do so in the Gambia. Our district tribunals, which are community-based customary courts, continue to be the most regular point of contact of access to justice for the majority of cases in the country. Their jurisdiction now extends beyond customary law matters to encompass some criminal offenses relating to public order, to sanitation, to public health, environmental and family matters, etc. Our National Judiciary Strategic Plan focuses on building up the capacity of these traditional courts in order to enable them to function more efficiently, more effectively, and to provide justice at the local level, rather than on their dissolution. Distinguished guests, any fair assessment of the legacy of international and of domestic justice will undoubtedly conclude that both have made very significant contributions to combating impunity in Rwanda, and even wider afield, in securing the accountability of the leading perpetrators of the 1994 genocide against the Tutsis. Both systems have indeed influenced the progressive evolution since then of the international criminal justice system to what it is today. The ICTR, while not directly focused on the issue of national reconciliation as a conventional court, nevertheless created, through its landmark achievements, the appropriate conditions and appropriate framework for national reconciliation in Rwanda following the genocide. Perhaps the greatest testament to this legacy of the tribunal, and thus of international criminal justice, came from the United Nations Security Council, when some 9 days before the tribunal's closure, the Council adopted Resolution 2256 of 2015 on the 22nd of December 2015 under Chapter 7 of the UN Charter. It welcomed the completion of the judicial work of the ICTR following the delivery of its last judgment on 14 December 2015 in the case of Prosecutor versus Pauline Nyiramashuhuko, often known as the Butare case. In that resolution, the Security Council acknowledged on behalf of the international community, and I quote, "The substantial contribution of the ICGR to the process of national reconciliation and the restoration of peace and security, and to the fight against impunity, and the development of international criminal justice, especially in relation to the crime of genocide," unquote. I thank you very much for your attention. I wish you a successful conference. Murakoze cyane.
Join me again to give a round of applause to both the previous speaker and the Honorable Justice Hassan Bubakar for their wonderful remarks. Before the online video, Ms. Kabasinga Florida took us through the launch of Certa Foundation's Kwibuka special issue, and we really commend the efforts done by the foundation. Thank you so much for the great work you're doing. And the Chief Justice of the Republic of the Gambia and the former ICTR prosecutor, Honorable Hassan Bubakar Jaro, took us through a deep reflection on the efforts done by the government of Rwanda in the wake of the 1994 genocide against the Tutsi and other efforts tried at the international level in dispensing justice to the victims and survivors of the 1994 genocide against the Tutsi. Honorable guest of honor, kindly allow me now to invite you to the group photo or invite the front table, the Honorable Chief Justice, the Minister of Justice, the President of the Rwanda Bar Association, Certa Foundation board members, and the representative of the National Public Prosecution Authority. I'll also invite everyone on the front seats on these tables in front. Kindly join for the photo. As the 8th President of the Rwanda Bar Association, where he exemplifies the steadfast leadership and a commitment to upholding legal standards. Fluent in Kinyarwanda, English, French, and Kiswahili, his linguistic versatility enhances his ability to advocate effectively for clients from diverse backgrounds. The third speaker is Mr. Ntete Gilles Marius. Ntete Gilles Marius is the Inspector General of the National Public Prosecution Authority. He worked as a lawyer in the Registration Department of the Rwandan Ministry of Justice before being appointed Chief Prosecutor of former Butare Prefecture in Rwanda. He headed different departments, criminality analysis in the Office of the Prosecutor General, Victims and Witness Protection Unit, and the Criminal Records Department. In 2006, the Cabinet appointed him as the National Prosecutor before being nominated by the High Council of Prosecution as the Inspector General. He is a part-time lecturer in Rwanda Schools of Law. He holds a master's degree in international law obtained from Louvain-la-Neuve University in Belgium, an English certificate given to him by the Anglican Church of Kenya, and he is now a PhD student. to give enough justice. The moderator, Maggie Waingana. Maggie is one of the firm's co-founders. She has a broad expertise in complex disputes and transactions. Her focus is on the company, investment, labor, and land laws, and designing large-scale contracts. Her sector specialties are energy, agriculture, education, and finance. Private practice aside, she has over 20 years' experience working for government and international organizations in the justice, health, education sectors. She serves as a trustee on the board of trustees of the IBA Foundation, a council member of the Rule of Law Committee for the East African Law Society, and is a member of the Rwanda Leaders Fellowship. She is passionate about mentoring young women professionals to maximize their potential and to live a balanced life while making tangible contributions to their communities. Maggie got her Bachelor of Law degree from Makerere University in Uganda, a postgraduate diploma in legal practice from Ugandan Law Development Center, a Master of Laws degree in government law and public policy from the University of the Pacific, California in the United States of America.
Well, by a constant round of hate speeches. 1957, the creation of the 10 Commandments of the Hutus. 2 years later, there was this massacre that led to many people being killed and others taking refuge. Then later on in the 60s. But what happened after the killings is what is important to note. Immediately after the killings, there was always a blanket amnesty. A blanket amnesty in the 60s, and I do believe that Marius will talk about this. He's an expert on this. He has done quite some research on this. Immediately after the killings, there was something which was a semblance of some form of justice. But later on, there was an amnesty, largely stating that whatever happened was in the context of a revolution, and therefore any crimes that were committed then are pardonable. That's what happened. So there were pardons in that framework of blanket amnesty. So forward to 1994, the genocide against the Tutsi. The genocide takes place, over 1 million people slaughtered, killed, 1 million Tutsis killed. And the calculations are that if you take 1 million in 3 months, that was around about 10,000 people every day. Now, if you take 10,000 people every day, and again, I want us to have this in perspective, we do have countries which have less than 10,000 people, almost 7 countries that I know of, which are countries which vote in the UN with a population of 10,000 people. So killing 10,000 people a day would be exterminating some of these countries. 1 million people, we have over 40 countries, I believe, of 40 sovereigns which have populations of people who are less than 1 million. Where Tembile comes from, I believe, Eswatini, the population now is 1.3 million, but I think in 1994, it was less than 1 million. So it's almost like taking the whole population of Eswatini or Djibouti and exterminating the whole country. So this is, sometimes when we speak about numbers, we also have to remember that these are not really small numbers, even though numbers are not what define a genocide, but it's also important to look at the numbers. So we have a population over 1 million people killed, over 120,000 people incarcerated, waiting for justice. We are told that we had a handful of people who had a law degree. The numbers do vary. I can't remember the exact numbers. Some do tell me that there were less than 50. We don't remember the numbers. I'm talking about a law degree, which in many countries is a prerequisite to serve in the justice sector, either as a judge or a prosecutor. So you can imagine, you can envision that particular environment in the aftermath of the genocide against the Tutsi in 1994. The justice system was practically non-existent. So what do you do in this circumstance? So there were quite a number of options if you wanted to copy and paste. The first one would have been to pretend that you will use the classical justice system that we had, the criminal justice system, and try people. Of course, we are told that if we wanted to do that, it would have taken Rwanda over maybe 150 years in order to resolve those cases. Then we had an option of sweeping everything under the carpet and pretend that the crimes did not take place. That was also an option, but will determine and reconciliation. And the answer is certainly no. The other option would have been to look at what was happening in other countries such as South Africa, what was known as truth and reconciliation. But given the history that I've given you of the violences that took place, mini genocides that took place, and what happened in the aftermath, that was a blanket amnesty. Is this the best way to approach Rwanda given that particular context, the Urugwiro meetings? The first challenge in the Urugwiro meetings was to bring together certain people. Some of them are people who had become refugees as a result of the violences that took place, and some of the people who served in successive post-independence governments, putting them together on the same table in order to discuss the future of the country was, I'm told, by people who were in that room, not an easy task. That was the first task, putting people who you'd want to refer to as the elite to sit together and decide the fate of the country was not an easy job. And there were quite a number of subjects to look into. One of them was the question of justice and reconciliation. What do we do handled? And I always tell people that by the colonizers was a prison, because in our justice system we never had prisons, which means that all the cases were dealt with. The reparation would be fines, actually, whether criminal or civil. The first institution built in Rwanda was the prison in 1930. And surprise, surprise, the law school was a crime of the magnitude of a genocide. So that's how Gacaca was created. I'm sure we are going to look into whether it was successful. But the direct answer now is yes. And we are going to show why later on. But let me hold here because I know we are going to discuss more on this issue. Thank you very much.
No, thank you so much for that good introduction. I like the fact that you said that we did not need to go do a copy and paste somewhere else, but we had to come up with our own option, the traditional tool towards resolving disputes. It's like homegrown solutions. Thank you so much. Now I will move to Mr. Ntete Jules, this whole prosecution of genocide cases. In your experience, what has been done to support witnesses and victims during the prosecution process, and how have you ensured their safety and encouraged their participation in the genocide, especially considering that these are not small crimes? Getting witnesses, getting victims, it's a very delicate issue. Just give us a highlight of what you've done throughout the process of dealing with this issue in the criminal justice.
Thank you very much. I think that is a very important question, actually, as we are talking of testimonies. As we are all of us know, in our developing country, be able to testify and feel free to come to us. Just in the 13, when you look at our laws, our criminal procedure code, we had some provision protecting victims, which was actually since 2013, protected victims and at least try to say something about witnesses. That is the first time in our country those two categories were protected. And Since that day, we then started to even use some techniques aiming at protecting both victims and the witnesses. We started use issue, and that is when then the unit started even to identify to invite local authorities to deal with the security of those witnesses and the victims. And that started to work systematically. The unit helped the prosecution to know where those vulnerable, and the local authorities really helped us to protect those two categories, which, if I can say so, create a kind of confidence in them, which was actually very challenging, not to have that confidence in somebody that you do expect to help you to obtain justice without nothing in return. As far as they were concerned, that was critical. But we also have a law on whistleblowers. This is also important. This is also important to have the law on whistleblowers. How can we protect those people who help us actually to achieve our mission? And the law is also helpful. And the other thing, I think, they do locate, but also in extreme case, when we identify or observe or discover that there is a very serious threat, we even take a very important decision to relocate them. We can even relocate them and help them to be somewhere where we do consider that at least it is more safer than the place and the areas where they are. And we also sometimes put them in our different safe houses. We do have safe houses countrywide. Of course, many people do not even know that we do have them, but as you can understand, these fall, of course, into the spirit and the need of protecting them. If you do call safe house, then it is not good to talk about it a lot. And all of these have been done just to encourage those people to help us to achieve the goal I have mentioned. So just to mention those few. Thank you.
Well, thank you so much for highlighting that. I've always been bothered. One of the criticisms when it comes to any types of crimes, or especially for our countries, they always focus on the rights of the suspect. Are they going to have due process? Do they have representation? You know, are they protected? It's always about the suspect, and it's never about how about the victims, how about the people who have suffered, how about the witnesses. So I'm really glad to hear the steps that have been taken. But you can imagine, he says it's in 2013 when the law came in force to protect victims and witnesses. So you can imagine all the lessons learned between 1994 and 2013. It's really something that is commendable. And for witness protection, I've only thought that we actually see that in movies, in law dramas, where we relocate a victim and give them new identity. I'm learning something very nice that we actually do that here, and that there is focus on protecting victims. Also, whistleblowing. It's we've usually heard of it in, you know, HR laws and labor laws, and but hearing it on the larger scale, there is a law. It's really something. I hope the young lawyers here and researchers are taking notes, and this is why we're here to learn. So we go to our beloved Batonier. This is my boss, so I am very honored to ask you these questions. I would like you to, first of all, start by telling us the journey of the Bar Association. Honorable Minister mentioned that he didn't remember the status of the lawyers at the time. Everything had been destroyed. What was the situation of the Bar and lawyers after the genocide against the Tutsi? Tell us about that journey, and tell us how the role of the Bar in the transformation.
Certa Foundation for having organized this conference. speaking of lawyers and advocates in this country, it's a long story. Why am I saying this? In the immediate aftermath of the 1994 genocide against the Tutsi, Rwanda did not have a professional body of lawyers or advocates that is set according to the accepted international standards. It's only in March 1997 that the first act of parliament was. Then you can imagine everything that was happening in 1997, only 3 years after the genocide against the Tutsi. It was a priority for the government. The truth of the matter is, because there was already a kind of visionary leadership that was going to see legal practice and play a crucial role in the justice system, especially the criminal justice system, because of the needs that were in place by then. So come March 1997, the Kigali Bar Association is created, and it's in August that the first 37 lawyers are sworn in before the then Court of Appeal. And you can imagine, with the thousands of suspects that were detained and others still on the run, 37 lawyers, the role that they were going to play in such a situation, it was pretty much like an impossible one. But the truth of the matter is, that very first step that was paramount, that was very important, was already put in place by the fact that
new approach, especially in Europe, of trying to bring some of the perpetrators to justice, which is a welcome, I do believe, move. But nonetheless, it's the cooperation that we do require is not yet at where we hope it should be. Given that if nothing is done and in a very fast mode, we will end up in a situation where many people will not face justice. Most of those who are the fugitives are getting old, of course. We saw the case of Kwibuka is a case in point where he suffered from dementia and he could not stand trial. So if nothing is done very fast, then most of these people, the 1,000 at least that are known of, will not be able to face justice, given that the biological clock is ticking very fast. Another challenge is when it comes to international cooperation, is that some of the perpetrators or some of the suspects, people who committed genocide here in Rwanda, some of them were foreigners, and I would speak of Burundians who are here in Rwanda. When you go to places such as Mayaga or in the southern part of the country more especially, you'll find that there are people who committed genocide who had names, I don't know what you call them, I don't know whether they are pseudonyms or nicknames, such as, I don't know, Mrefu or other names which were not the names of those people. And when you go to commemorate, especially when you go to the southern part, people can relate and tell you that there were some people who killed us, but you cannot get the exact identity so that you can even be able to follow or even issue indictments to different countries. So these are some of the challenges. But the biggest challenge, of course, is lack of political will of some of the countries to bring to book some of the people who we already know, and we have complete files that can be tried either here in Rwanda or in the countries that they find themselves in. However, let me take this opportunity to thank a few who have cooperated, especially the mechanism, ICTR, the cooperation that you find together that was built between Rwanda and the mechanism over the years, of course, it wasn't that smooth at the beginning, but over the
considering that these crimes never get old, even if they get old, we still read in the news some of the Nazi people being captured when they're 90 or even older. So wherever they are, their crime will find them out. But what is being done in terms of tracking and arresting and prosecuting from the National Prosecution Service?
Thank you very much for that question. I think as everybody can understand it very easily, after the genocide that occurred in 1994, the prosecution was supposed to do something. I think that it was one of the organs that actually was very highly concerned. And the first thing that has been done in prosecution, so apart from investigating since 1996, investigations were actually conducted, but in a general manner. But to come back to that specific question of people who were actually outside the country, I think it is important to mention in the prosecution the creation of the specific unit that was supposed to deal with the fugitives, genocide fugitive tracking unit. That is a unit that was created in 2007. And the unit had the mission to investigate and produce indictment and international arrest warrant to be sent outside the country where those people were shot. And that was done since that day, that year, 2007. And this is a unit that was created by the cabinet. And the unit started investigations and to draft indictment and to identify with the other organs, especially embassies and Interpol, to know where those people were. After knowing where they were located, those indictments have been sent in the respective countries. Today, we do account 1,149 indictment and international arrest warrant, which were sent in different countries. It is unfortunate, as the Honorable Minister has just mentioned, some indictments have been sent in African countries, which unfortunately are not cooperative. The political will is completely lacking. We do send those indictments, they do not react. As he has just mentioned, several indictments have been sent in DRC, and sometimes they do prefer to come in this country conducting investigation and prosecuting those perpetrators in the respective countries. And the second activity, as everybody can understand, is assisting those rogatory commissions. We do assist them, and the unit I have just mentioned assists a lot. The Witness and the Victim Protection Unit is the unit that assists some rogatory commission. When countries decide to come in Rwanda and investigating according to indictment sent in the countries, we do assist them. Our prosecutors, the unit, are there to assist, and also, as you can understand, the specialized unit, which is now called International Department Prosecution, International Prosecution Department. And that is the department actually that deal with the assistance to those rogatory commission. And something other issue to mention and to highlight is that when we do send those indictment and international arrest warrant, and our prostitution is part of a member of some international organization and regional organizations of prostitution. We are in International Prostitution Association, we are in the African Prostitution Association, we are in the East African Association of Prosecutors, and all of those forums are key to help us. When we are in those conferences, we every single time invite our colleagues to remember that they do have our international arrest warrant in their countries, and we do invite them to do something on them, and this is also important, but something also important is to know that we do have now important laws. We used not to have mutual legal assistance law. This was a challenge, and this is now resolved, and it is important. That kind of reciprocity is key, and also we do have a transfer law. All of those laws were not in place when we started dealing with these very crucial issues. And now we are happy that at least we do have laws on one side, but on another side we do have different forums to use those associations, and the embassies are there to help and engaging different countries to react on our international arrest warrant and indictment sent in different countries. And some statistics are going to be shared. At least we do account today 30 cases outside tried, and 29 people brought back to our country to be prosecuted. I thank you.
Wow. That's just amazing. I'm inspired by the fact that our country does what is necessary, because if it doesn't work, they still look for solutions. So they have come up with creative ways, like you were saying, using our embassies, using our memberships in different regional and international bodies to keep nudging and insisting and, getting the collaboration of other people. It's really inspiring to hear that all these creative ways are being employed. It's not enough to say we have the laws in place and we have the units in place, but they go an extra mile. I think you should give a hand of applause to our prosecution service and generally our justice sector. And we'll continue on that collaborative objective with even our own bar association. Can you tell us how the Rwanda Bar Association has partnered with people in helping with the access to justice for the survivors and families of the victims of the 1994 genocide against the Tutsi? How has the bar really reached out to other people to help, especially in access to justice?
Thank you, Maggie. First of all, I want to commend and publicly thank the Ministry of Justice. The government of Rwanda through the Ministry of Justice. The reason is we have a long-lasting and strong partnership with the Ministry of Justice to make sure that even when these cases of these people are suspect of the genocide against the Tutsi comes back to the country, we ensure that they have representation. If I have to tell you the truth, you cannot imagine how much money the government of Rwanda have paid or even sent in Rwanda. They go through trial that are fair with necessary representation. I think it should be last week, I was having a conversation with Dr. Charity here present, and she was telling me that they are actually even about to send us more kind of funds to make sure that the lawyers that are involved in these cases are also given the possibility of being paid and be able to handle the matters according to the accepted international standards. So on top of the Rwandan government putting in place the Bar Association, there was also those kind of initiatives that aim at making sure that fair justice and access to legal counsel is not something that is only in the books, but also a reality, including even the suspect of the 1994 genocide against the Tutsi. So that's a part that is very important. Our collaboration and our way of working has really helped us to reach out to a good number of people. But also on our own, as I said, we have this kind of pro bono work that we give to these vulnerable people that cannot afford to pay legal fees. We have a very strong partnership with Avega Agahozo, which is an organization of women that are survivors of the 1994 genocide against the Tutsi. We have a partnership with Kwibuka. Our colleague Janvier here, we probably have an opportunity to tell you about that. But the main message that we are sending is access to justice and representation should not only be for those who can afford to pay legal fees. And that was not going to be possible if the Bar Association was not established, if we had not increased the numbers of our members, but also the quality and the kind of, I would say, the expertise, like the same way the Honorable Minister was saying. But today, if you ask me if we've ever reached where we want to be, I will tell you no. But then I believe it's a work in progress. Thank you.
Okay. That's amazing. Thank you so much for those insightful sharing. Now, I want us to go now, going forward. We all know that we have a young population, and the youngest people here were not even born at the time the genocide against the Tutsis happened. Honorable Minister, what is your ministry doing, or what is the justice sector doing to ensure that the genocide denial is not going to be something that we have to worry about? What are we doing to educate the young people and to keep this information available for the young people to prevent denial or misunderstanding of the things that happened, especially for the younger generation? How are we talking about it? What are the efforts are your ministry putting in place to address this?
Yes, thank you very much. First of all, in order to understand how dangerous denial is that the main reason that there is denial of a genocide as one of the steps of the genocide is so that the justice is not attained, because if you deny the genocide and you succeed, then people will not be brought to justice. And this was something that was tried not only in different platforms, but even in courts. I do believe at the time when in the ICTR, the court decided to make a judicial notice on what genocide was, it was because there was constant denial of what genocide was in the court itself. So there are many avenues or platforms where denial takes place. The ones that we commonly see are in universities. Certain universities have resorted to giving platform to deniers. And the only way to deal with this is to, in the justice sector, try to put out facts as much as we can, including sometimes going to the universities or even working with some of the practitioners who are happy to be given proper facts, because you have people who want to go and really say what the truth is, but they do require that you come up with proper documentation. I can give you an example of a very subtle way of denying genocide that we managed to, as a ministry, to work together with others in order to deal with that. It was even the question of why it's called a genocide against the Tutsi. I do remember working together with some practitioners in a country that I will not name, and when we went there with certain practitioners, they kept on asking us this question. Some of them they wanted us to change the nomenclature and just call it the Rwandan genocide. And we sat with the practitioners together with, in the same room, and in order to make them understand why it is a genocide against the Tutsi, we had to look at what a definition of a genocide is. Because most of them would try to come up with these ideas that the reason why we think it's a good idea for you as a Rwanda not to call it a genocide against the Tutsi is that you're trying to build another nationality devoid of Tutsi, Hutu, or Twas. But the argument was, and it's a strong legal argument, because most of the arguments surrounding genocide are sometimes political, it's fanatical, so you need to bring it to the level of laws in order for people to begin to even to understand the concept itself. So the argument was that when you look at the definition of what a genocide is, in the 1948 convention, of course, the Genocide Convention, a genocide, there has to be an intent to exterminate a given group. So if you want to call it a Rwandan genocide, there is no group which was Rwandan. And if it was there, there was no intention to exterminate a group which was Rwandan. Of course, that was one of the arguments. And then the second was that when you go to the case law, the ICTR laws, you bring together all these legal facts, the judicial notice, and why it was important to really designate the genocide as the genocide against the Tutsi. Then when you have these legal facts put together, you share them with others in order to go to these universities and deal with it, with these deniers who are given platforms. Another way is, of course, to look at the arguments of the deniers. It's quite interesting that when you pick a report or even a book of one of these genocide deniers, and you look at the footnotes, you may be tempted to think that they have factful reasons if you are maybe someone who was born after the genocide. But if you just do some bit of research and go deeper in what is being referenced and go up to the source of where the referencing started, an example is the mapping report, because this is one of the reports that is relied upon by the deniers. When you go to the mapping report, which is where it all began, what they call the evidence of double genocide, or even that the genocide was not against a particular group, but it was killings. When you go back to the source, which is the mapping report, you can easily deconstruct it, because when you look at the methodology of the mapping report, and I implore anyone to go and look at the mapping report, the methodology was that, and this is not someone else saying it, it's them saying it, the authors of the report, was that they interviewed 300 people who are not identified because they want to protect them, 300. And then they came up with a formula that ended up with the number that they say was another genocide that took place. So that is how it is. But unfortunately, when you look at, say, a book today written by one of the deniers, because they've created what you can call an echo chamber where they self-reference each other. Someone who is not keen enough to go to the source, you may think that this is a well-researched document. So what we try to do together with other stakeholders is to look at the source and the sources and the informations of the deniers and really deconstruct them. So this is one of the things that we try to do in the justice sector. Together, of course, with all of you in the justice sector, because justice sector is not only the Ministry of Justice. It involves a lot of people, including the Bar Association. And I know that the Bar Association has played its due role in dealing with the question of, denial of genocide, which is extremely dangerous because you don't want justice to take place, but another bigger issue is that you probably want to come and complete what you did not complete because you are denying what the facts of what took place. One of the most worrying, the most recent one that I saw this week, again, the reason why it's difficult to deal with denial is that it changes form every now and then. When you deconstruct one part, when the ICTR, for example, through the judicial notice state that pointed out that it was a genocide against the Tutsi, the denial of whether the genocide took place, you can see that it has diminished. Now it has moved to saying, to stating that there were 2 genocides, and now the people who deny the genocide are not necessarily those who committed genocide. Maybe some of them are their offsprings or others, or their collaborators. So it becomes a bit tough in dealing with this. The most recent one that I saw that is beginning to be developed, I think it was developed either last month, another trend. It's an interesting one. You can follow it up and see. There are some people who are trying, and it's a group of people who are trying to say that the head of the Interahamwe was a Kajuga, and they claim that he was a Tutsi. So the genocide was committed by Tutsis. So this is another narrative which is growing. So you can see it changes form. Because of course the deniers thrive on falsehoods. So it's easy to deconstruct them, but unfortunately, it's like dealing with, what do you call this thing that the children play with, slime. So when you're playing with it, it finds a way of, but you also have to keep roots. So the question of the only way to deal with deniers, and I implore the young people here, it is a question of who will blink first. So the deniers do hope that those who speak facts about the genocide will blink first. So it's a question of who will tire first. So we don't have to be tired. So all of us in this room, I call upon all of you, because it's not only the Ministry of Justice, it's all of us. It's a responsibility that we have to fight denial, because it's the only way to ensure that what happened in this country will never happen again. Thank you very much.
Wow, thank you. Wow, that's really important. I have a 15-year-old daughter who recently asked me about this same question because she had read in her SST notes about all sorts of, things, a double genocide, and she was asking specifically why it's called a genocide against the Tutsis. And we've seen people deliberately call it the Rwanda genocide. I recently saw a lawmaker in the US also go on the air and say, oh, the Rwanda genocide. And I think it's not a slip of a tongue, it's intentional. And I've not seen, maybe it's because it's been so many years, the same level of denial with, for example, the Jewish Holocaust. I haven't seen the efforts. Maybe they were there at the time, 20, 30 years after the Holocaust, but we see it mostly here. And so I just want, IG, tell us also, what are some of the efforts that you're making to combat denial? What are some of the forms that you have seen it in as well? Just thoughts to share with us, and how can we encourage, like the Honorable Minister says, even the younger generation, even our children, so that they know where we're coming from, what is, starting by properly calling it what it is, so that we can understand what have been the efforts of the national prosecution in combating denial.
Thank you for the question. I think as a prosecution, the first thing to do is actually prosecuting perpetrators. And as everybody here can understand it, that is our first goal and mission. So to prosecute suspects, perpetrators. But it is not easy at all, as the Honorable Minister has just mentioned, because it has been even discovered that we who are in the area do not even understand clearly the provisions our laws. Technical terms are so complicated, and actually allow me to even acknowledge that laws came late because, as everybody knows here, we started to prosecute and to investigate on such laws in I mean, the laws have been enacted, laws in regard to that matter were enacted for the first time in 2001. That is when we started to punish divisionarism and discrimination. That was the first time. And the laws on negation, minimization, justification of genocide, and the other related offenses were punished were punished for the first time in 2003. So you can understand, before 1994, when the genocide occurred, and the first laws to punish offenses related to denial. The first time, that is 2001. 2003, that is the first time for Rwanda to punish international crimes, new international crimes, that is 2004, and 3, with some provision on negation, minimization, justification, and other related offenses. Already you can understand where the problem was. And the country actually punished for the first time what we do call genocide at the origin. For the first time, that is 2008. That is for the first time. Genocide at the origin. 2008. That law was amended 2 times. That is 2013 and 2018 to adjust and try to have a better law. So already what I am trying to explain is that we can observe already a certain delay in enacting the needed laws to be able to prosecute perpetrators of those serious crimes. And then we started to observe very quickly the miscommunication and lack of harmonization and understanding of those crimes. And the first thing to do for the prosecution is at least to try to explain to our prosecutors and, of course, investigators, and on another side, judges, to understand then those crimes. Because even today, something can be qualified. I have taken place and took some samples of some cases to try to analyze and to see if people do understand, being judges, prosecutors, and investigators. And unfortunately, I immediately realized that it is full of total confusion. People mainly do qualify as a genocide ideology what is supposed to be violence against victims of genocide. Everything related to ethnicity in this country is immediately qualified as a genocide ideology, which is not true. And this causes a very serious problem, because if there is a problem of qualification, people can either being prosecuted for other crimes rather than what they do commit, or simply not being prosecuted because of lack of clear understanding. So what I am mentioning is that actually we have taken the time and try to explain in different forums, trainings. We took our time to train our people so that we can have a common understanding on those technical terms. At least we are happy today that our people do now understand, and we have done a lot so that we can have that common understanding of those technical terms since 2001 up to 2018. People do now understand those crimes. Second, what we decided to do is at least to give a particular attention to those crimes. What I do call particular attention is giving priority to those crimes. Why? Because our prosecutors do know very well that those are crimes that can immediately destruct this country, as it is directly linked to the normal life of the society, and they do understand that the aftermath of genocide is critical, and they need to stand and work hard on those crimes. Then, when we do receive files of those crimes, then those files are taken with the first priority, and that is the policy and the decision taken by the prosecution. And the third is to measure the conviction rate as what we do call in the prosecution performance indicator. So it is not sufficient to investigate, conduct investigation and prosecuting the people in that area, but also it is extremely important to know if people are convicted or not. Do we success? Do we win those files, or we do lose them? And this is done through what we do call conviction rate. And the conviction rate is our first performance indicator as a prosecution. And for example, in 2009, the conviction rate was very low, turning around 76%, meaning that at that time, around 24% were lost. And this was a challenge, but we are now happy that we are around 90% of conviction rate, which is okay. And this is based on trainings I have mentioned, and the particular attention given to the prosecution of those crimes that are critical when we do remember that we are in the aftermath of a genocide, and we, as the Honorable Minister has just mentioned, it is to be focused and stressed that by ignoring that first priority, it is easily possible to have a new genocide. And we really need to tackle that from the root, so that people can be aware of that risk, and then working hard, tackling the root, avoiding another genocide. That is what we do in the area. Thank you.
Wow, thank you so much for that. I like how you started by giving us a chronology of the laws that were put in place, and how for the first time we had a law against even the genocide ideology, and it was amended and refined to make it very good. I remember some of the criticisms we used to receive was, okay, Rwanda is now punishing people for thought, just for thinking. And then the law was clarified, and we just sometimes take it for granted. We don't realize how much work that these institutions of justice actually do for us, and for promoting the truth, and for making sure that the true facts are known. They go out of their way. In addition to working on legislation, they are doing trainings, they are paying particular attention. They are looking at their own KPIs, or their performance indicators in what is the conviction rate they're getting for these. These are all amazing efforts. I think we should really applaud the justice sector. Are you still awake? I'm just checking to see that you're still awake. So just briefly, Monsieur Bâtonnier, tell us, briefly, what is the Bar Association doing in promoting historical truth-telling? What is the Bar doing to make sure that the true facts are known and are shared and are passed on from one generation to another?
Thank you very much. First of all, that's the reason why we are here. And when I gave my welcome remark, I did say that the people that were invited to this forum, they are specific people that we think can share their expertise and their experience with the young ones that you see in the room. That's number one. Number two, each and every year, Rwanda Bar Association has a kind of event that happens for Kwibuka. The reason we do that is because we have members that never experienced this kind of tragedy and atrocity of the 1994 genocide against the Tutsi. But the purpose of doing so is to make sure that they understand our history and then be alert on whatever kind of, even this kind of denial that we are talking about. The very tricky part, if I have to speak a bit about denial, is the fact that nowadays the people that are involved in the same kind of ideology are people that were still at a lower age when the genocide happened. For those of us who are on Twitter, we can tell it's pretty much like the second or the third generation that is involved in this kind of denial. It's therefore important that we keep on passing this kind of history so that the young ones can really understand and avoid anything that can lead again to the genocide against the Tutsi. And maybe for purposes of making it clear, the reason why we do that event of remembering each and every year is because among the people that were doing a legal practice that is similar to the one of advocates in Rwanda, regardless of how they were limited before the 1994 genocide against the Tutsi, 15 of them were killed. 15 of them were killed, and even though the Bar Association was created in 1997, it does not remove from us the responsibility and the duty to remember that very history so that it can serve if such events happen again in the future. Thank you.
Well, thank you so much. I think you have done a wonderful job. I see our MCs coming up. That is our cue that we've run out of our time. I thank you so much for the insights that you've shared. It's really important that we preserve the memory. It's important that we fight genocide denial. And once again, we would like to thank the Certa Foundation and the Bar Association for putting up such an amazing panel. And thank you so much for all the insights that you have shared.
Thank you so much, Maggie and the panelists. Many thanks to the Minister of Justice, many thanks to the President of Rwanda Bar Association, and thanks to the Inspector General from National Public Prosecution Authority. I'm very confident that this was a very enlightening session, and I have no doubt that everybody in the room, we learned a lot. So that has been a discussion on the reflection of the domestic status of criminal justice, and the panelists have really done a great work to take us through 30 years of resilience. A lot happened within these past 30 years right after the 1994 genocide. Thank you so much. I am now proceeding with the next panel. I told you this is going to be a long day, very packed, but of course full of learning opportunities. The next panel is going to be now focusing on the international aspect. It's called the International Criminal Justice, Investigating, Tracking, Arresting, and Prosecuting International Genocide Fugitives, a reflection on the work of the International Criminal Tribunal for Rwanda, ICTR. That being said, allow me to invite Dr. Charity Wibabara. He's going to be our moderator. Charity Wibabara holds a PhD in Transitional Justice and International Criminal Law from the University of Western Cape in South Africa and the Humboldt University in Berlin, Germany. She has a master's degree in Transitional Justice and Crime Prevention from the University of Western Cape in South Africa. Her bachelor's degree was obtained from the National University of Rwanda School of Law. Currently, Wibabara Charity is a principal state attorney and head of the Department of International Justice and Judicial Cooperation at the Ministry of Justice. From 2015 to February 2024, she served as a national prosecutor at the National Public Prosecution Authority and was also the coordinator of the International Crimes Prosecution at NPPA. Before joining the NPPA in 2015, she was a full-time lecturer at the University of Rwanda, Faculty of Law. Besides the above, Kwibuka Charity has published a book on Gacaca Courts versus International Criminal Tribunal for Rwanda and National Courts Nomos Vergas Baden 2014. I'm not fluent in Dutch. So that is Dr. Charity, who is going to moderate this session. A round of applause to her. The panelists, number one is Dr. Charles Adegun Phillips. Charles joined the Office of the Prosecutor at the United Nations International Criminal Tribunal for Rwanda as a legal advisor from practice as a solicitor in the United Kingdom, having been appointed by the then Chief Prosecutor of the UN ICTY and UN ICTR, Justice Louise Arbour, Judge of the Supreme Court of Canada, and later UN High Commissioner for Human Rights in January 1998. In March 2001, at the age of 35, the then Chief Prosecutor of the UN ICTY and UN ICTR, Ms. Carla Del Ponte, former Attorney General of Switzerland, appointed him as a senior trial attorney and lead prosecution counsel for the Kiwia and Kigali Raw trial teams in the Office of the Prosecutor. His mandate was to lead teams of international criminal lawyers and investigators in the prosecution of persons who bore the greatest responsibility for the massacres in the Kibuye, Bisesero, and Bugesera regions, the main Tutsi strongholds during the 1994 genocide against the Tutsi. He also served as the head of special investigations at the UN ICTR between 2008 and 2009, having been appointed in that capacity by the then Chief Prosecutor of the UN ICTR, Justice Hassan Boubacar Jallow, the Chief Justice of the Gambia, who addressed us this morning. He was educated at the Grammar School, Lagos, Nigeria's first secondary school, founded in 1859, and at the prestigious British boarding school, Repton, founded in 1557. He read law at Warwick University, from where he graduated in 1989, and at the School of Oriental and African Studies, University of London, where he obtained his master's degree in law and solicitor of the Supreme Court of Nigeria in 1992, and in 1996 as a solicitor of the Superior Courts of England and Wales. Welcome to the panel, Dr. Charles. The second panelist is Tembile Segote. Tembile was appointed as the senior legal officer and officer in charge of the Office of the Criminal Tribunals in 2020. Previously, she served at the International Criminal Tribunal for Rwanda as a legal advisor from 2006 until 2009, and as an appeals counsel from 2010 until 2015. Closer to the end of the mandate of the ICTR, she transitioned to the then Mechanism for International Criminal Tribunals, where she served for a few months. She then joined the African Court on Human and People's Rights, where she served for a year as a principal legal officer from 2016 until 2017. Thereafter, she rejoined the International Residual Mechanism for Criminal Tribunals as a legal officer. Prior to her, she holds a master's degree in law and development here in Rwanda. Ms. Kawasinga is the founder and executive director. As managing director of Certa Law Chambers, Florida and her team found themselves receiving and litigating cases of SRHR and gender-based violence pro bono. As a result of working closely with other national and international organizations in this field, including Women's Link Worldwide, Florida decided to start the foundation to enable this work to be of the law firm's corporate social responsibility. Florida brings a wealth of experience both internationally and domestically. She has 2-decade experience as a prosecutor and in private legal practice, including in strategic litigation and public interest litigation. She's also a certified mediator by the International Institute of Mediation and Conflict Resolution, and a prolific arbitrator with Kigali International Arbitration Center, where she represented international and domestic clients, including the International Union for Conservation of Nature. Ms. Florida holds a Master's of Laws, magna cum laude in International Human Rights Law from the University of Notre Dame, Indiana, USA, and a Bachelor of Laws degree from Makerere University, Kampala, Uganda. She has also received various trainings from prestigious institutions, notably the University of Pretoria, South Africa, Erasmus University, The Hague, Netherlands, and Chartered Institute of Arbitrators in London. She has taught at different times international criminal law, including at the Institute for Legal Practice and Development in Rwanda, for female advocates under the auspices of the Rwanda Bar Association, aimed at inspiring and raising their capacity and profiles in the practice of law in Rwanda and in the East African community. Ms. Florida has previously worked for the government of Rwanda as a senior legal advisor to the Prosecutor General and the International Crimes Unit at the National Public Prosecution Authority. Ms. Florida has extensive international experience as well, having worked at the Office of the Prosecutor, United Nations International Criminal Tribunal for Rwanda, the ICTR, as an appeals counsel, assistant appeals counsel, and case manager. Ms. Florida is a member of the Rwanda Bar Association, the East African Law Society, the American Bar Association, the International Association of Prosecutors, and a member of the Chartered Institute of Arbitrators at the Kigali Arbitration Center. She speaks at various conferences, among others on international humanitarian law and international criminal law all over the world, most recently in Washington, D.C., Michigan, Nairobi, and San Diego. She speaks 3 languages, namely Kinyarwanda, English, and Kiswahili. That is the panel that is going to dive us into a reflection on the international criminal justice, on how investigations, tracking, arresting, and prosecutions of international genocide fugitives are carried out. I hand over to you, Dr. Charity, and kindly keep time. Thank you so much.
Thank you very much. Once again, it's really humbling to be a moderator on this eminent panel of various experts in the field of international criminal justice, and I'm expectant, actually, and looking forward to learn a lot from their wisdom, their knowledge, and their experience. It's also an honor for me to be the moderator of this session, but before the audience, as I look around, I see different experts, legal practitioners, researchers, academicians. So I'm also looking forward when you share your views or when we have time for questions, and I believe time will allow us. This panel is not going to take very long, so we beg your attention so that you follow you follow the presentations by the different panelists. I cannot proceed without appreciating the previous panel. They actually did a great job. If we can clap for them again. Yeah. They laid foundation for this panel, so our job is not going to be hard because of what they've really done. So once again, join me in giving a round of applause to our esteemed panelists, and we are looking forward, like I said, from hearing or sharing your knowledge from experience, your expertise. And on my immediate left, Florida Kabasinga, you're welcome. Right at the center, we have Dr. Adegun Phillips, welcome. And welcome, Mrs. Tembile, to this panel. I'm starting with you, Florida. Looking at the theme of this panel discussion, it's investigating, tracking, arresting, and prosecuting international genocide fugitive, reflection on the work of the ICTR. When the International Military Tribunal was established, that's the Nuremberg Tribunal was established in 1945, one of the principles that it introduced was the concept of individual criminal responsibility. And the statement that the tribunal made is that international crimes are committed by men and not abstract entities. And they say that it is by punishing the individuals that commit international crimes that the provisions of international criminal law can be enforced. So as we said, we are looking at the reflection of the work of the ICTR. Do you think the ICTR actually reached its mandate of prosecuting these international fugitives? And as you're saying that, as you're responding to that, I would love to hear from you by making reference, feel free to make reference to the initial ICTR case, the Akayezu case, and other cases. Can we say that the ICTR has had an influence on Rwanda? Can we affirm that the ICTR has had impact on the domestic prosecutions in Rwanda? Make reference also to any challenges. I like quoting Antonio Gazese, one of the prominent authors in the field of international criminal justice. He made a statement and said that these international criminal tribunals, and he was specifically referring to the ICTR and ICTY, they are like giants without arms and legs. So should we consider the ICTR in the same way? Please go ahead and tell us more about it.
I hope my voice will be able to carry. To begin with, I would like to recognize the presence of one of our board members who just joined us, Mr. Andreas Spitz. Welcome to this conference. Andreas is here to help us as well train IP. Charity, your question is quite loaded. But of course, after the Nuremberg trials, there had never been any trials or practice from which the tribunals of the ICTR and ICTY could actually borrow a leaf from. So we literally had to create things as we went along. But in terms of what happened in this country, it was extremely important. I think the Minister of Justice and the Chief Justice have mentioned in their speeches how this country was broken post-genocide. So the International Criminal Tribunal was created to try the most high-level perpetrators because it did not have the capacity to try very many perpetrators and accused. The nature of international criminal justice is sometimes misunderstood because you bring together a lot of practitioners from different countries. You bring together people from different backgrounds, from countries that practice law differently, people who speak different languages. But when it comes to international fugitives, which is what Charity has asked me about, I totally believe that the presence of the ICTR contributed a lot to ensuring that the key perpetrators were tried. The reason is, post-genocide, this country had too many needs. Everything was broken, and obviously the key perpetrators had the ability to go far and wide in the world. I think recently, majority of you who are Rwandans, you've seen a fugitive on the streets of Australia. So if Rwanda at that point had to concentrate on finding these fugitives, it would have been an uphill battle. Rwanda didn't have extradition treaties with many countries where these fugitives were found. But the ICTR had a mandate from the Security Council of the United Nations that required countries to actually cooperate in the arrest and transfer to ICTR of these key perpetrators. So imagine the key perpetrators who, like the likes of Bagosora, the likes of Zigiranyirazo, the likes of the former generals in the army, they had friends all over the world that could have protected them. And indeed, there was an effort to protect them. However, the ICTR went after them with resources from the international community. I think that allowed for Rwanda as a country to concentrate on other things at the time. But there's also a myth that I want to demystify today. It is not true that ICTR did a lot to transfer to Rwanda in our legal practice. In fact, it went both ways. And the reason why I say this is international criminal tribunals do not have a lot of the resources that are needed to conduct trials and prosecutions internationally. They do not have a police force that can arrest. They do not have the capacity to give travel documents. These are things that are left to national jurisdictions. So if Rwanda had not cooperated to even protect witnesses and survivors, it would have been difficult for the work of the tribunal. Let us also not forget that the genocide that happened here in Rwanda that was being prosecuted by domestic courts, that was also being investigated and prosecuted at international level by the ICTR, is the same genocide. The perpetrators were the same. There's an argument that this genocide was not planned, but indeed, there was a plan. If you look at the history of the genocide, which comes through testimony of witnesses, documents, through testimonies of experts, you actually realize that the genocide was organized from the top all the way to the local levels, the smallest local levels in different parts of the country. So in Rwanda is where you actually found the perpetrators, majority of them. In Rwanda is where you found the witnesses, and it's where the government actually took steps to protect survivors and witnesses against persecution. So if you look at the ICTR statute and rules and regulations, in fact, when it came to things like sentencing, the ICTR trial chambers and appeals chambers had to refer to the sentencing practice in Rwanda, which is why you find initially majority of the accused, in fact, ended up with life sentences. So it was a two-way street. But in 2017, something happened. Sorry. We had what we call the transfer law. The transfer law, it was realized quickly because the ICTR was an ad hoc tribunal. It was going to close its doors, and that would leave an impunity gap. So then it was agreed that cases would be transferred to domestic jurisdictions, and which domestic jurisdiction was more interested in trying the perpetrators than Rwanda. So there was a transfer law that was enacted. And at that time, it's law number 11 of 2007 concerning transfer of cases to the Republic of Rwanda from the ICTR and from other states. A lot of the provisions in that law, in fact, allow the courts in Rwanda to refer to evidence that was collected by the ICTR and to refer to expert reports, forensic reports, video evidence, written statements. So all of those things would be transferred to the domestic prosecutors and investigators to be used in cases where they were relevant. So also principles of common law came into practice in Rwanda in a judicial system that was mostly not common law because we have the French background, so a lot of the practice here was civil law. But then we started doing things like cross-examination and other things that were not in our legal practice before. Also, the collaboration between the two ICTR and domestic judicial practice here was very, very important in successful prosecutions at the ICTR. I'll give you an example. The Witness and Victims Unit at the NPPA, which the IG has spoken about, this is perhaps, and I'm not exaggerating, this is perhaps the most effective witness protection unit in the world domestically. And people don't know that. It is a lean unit, but that does exceptionally great work in following up with witnesses. I know they don't talk about it a lot, and they don't praise themselves a lot, but the ICTR and national jurisdictions that are trying cases of genocide in different countries, in Denmark, in Sweden, in other countries, they rely on them a lot, in terms of protecting witnesses, in providing logistics for witnesses to travel and testify in different countries. So all of that, I believe, yes, ICTR has influence, but there has also been a collaboration between the domestic justice system here and the international justice system at the ICTR. Thank you, Charity.
Thank you, Florida. As a follow-up, that was informative, actually, and insightful. You say that genocide to happen has to be planned. But if you look at the case example of Bagosora within the ICTR, he was convicted, but he was never convicted of conspiracy. Isn't there a contradiction because we have people who are not actually even masterminders here, who have been convicted of conspiracy to commit genocide, and Bagosora himself was not convicted of conspiracy. So don't you find a contradiction?
Actually, the truth of the matter is when you come to proving crimes in a court of law, it's different from what people actually know to be a fact of, for example, common knowledge. When you look at what happened in this country, there were mistakes made by prosecutors at the ICTR as well, because this was something new. We all thought this is one genocide, so everybody can actually be banded into one indictment and prosecuted, which was completely wrong. So you have Bagosora at the top of the tier of perpetrators. How do you connect him legally to a cell leader somewhere in Cyangugu, legally? That's not to say that if you have not proved in a court of law that a plan to commit genocide was in existence, it does not mean that the person cannot be convicted for genocide. Now, for Bagosora to have conspiracy, the cases where we succeeded in actually finding perpetrators guilty of conspiracy were cases where you could literally connect the perpetrators. If, for example, you went to a prefecture in Cyangugu or Chibuye, you could actually connect the dots factually, because from a national level, they went to the villages, first to the prefecture, then they went to the sectors, then they went to the cells. That's how it was organized. So you can actually connect the prefect to the leadership of the sector, to the leadership of the cell in different places. So that conspiracy you had to do. The other challenge was to get perpetrators to actually testify against others that they were together in a plan. That was extremely difficult. The only chance we had at some point was Kambanda, who pleaded guilty, and then he recanted, because he had actually in his plea agreement stated some of the planning, evidence of planning. But getting the perpetrators to actually tell you how these plans were hatched and implemented, because in the rooms where those things were said, you have to know that not many people had access, and everybody was protecting everybody else. I remember we had a case where we tried to get somebody to testify against another person who was at the ICTR, and he said, you know what? In fact, my children are being looked after by his family outside, so I cannot dare actually testify against him. Also, when you talk about people like Bagosora, there was a lot of intimidation that went into these things. When you look at the evidence that we had, and even that is available publicly, even the language that was used by perpetrators was couched in such a way that it did not speak directly that we are going to do this. So the language was always tugiye gukora, we are going to work, we are going to do this. So then proving that kind of language in a court of law, that in fact it meant this, took a lot of legal work, which was sometimes almost impossible. We all knew what they meant when you said tugiye gukora, they are going to massacre Tutsi, but in fact, is that the only thing that they meant? Because that would have been the legal standard. Thank you.
Thank you very much, Florida. Coming to Dr. Charles, given the fact that you are a prosecutor in the ICTR and actually a lead prosecutor, can you help us understand more on the dynamics and complexities that were involved in investigations and prosecutions? And I would love that you also make a reflection on the media case by telling us also the challenges. I know, we know in the Nuremberg, we know about the stretcher case, but if you look at the nature and the work that the ICTR was doing, it was kind of unique, new, and unprecedented. So how were you able to handle those challenges? The floor is yours, sir.
Thank you. Let me start off by saying that it's always an honor and a privilege to return to Rwanda. And as you've heard, the very formative part of my legal career, I think I was probably 3-4 years qualified as a lawyer when I joined this very important work. And so, unlike most people who end up in an international career, having started from a domestic career. I actually did it the other way around. I actually started with an international career and then reverted to a domestic career. So as a foundation member of two very unique experiments, and I say this without equivocation, that this is a very unique experiment in the history of mankind. Since the Second World War, these were very unique experiments. I was privy to a lot of the challenges that were involved in both the investigation and the prosecution of very large-scale international crimes. And there are essentially 6 or 7 of those challenges that I want to speak to this morning. The first, which you've heard a lot about already in the course of today's proceedings, concerned the formulation of investigative strategies. How did we develop a criteria to determine those who bore the greatest responsibility for genocide? As you've heard from Florida's contribution and that of Hassan Jallow, the ICTR was not designed to go after foot soldiers. The ICTR was designed to go after the persons who bore the greatest responsibility for the genocide against Tutsi. And that emanated from the preamble of Resolution 955, Security Council Resolution, which established the tribunal. So how do we determine those who bear the greatest responsibility? That was the first challenge. The second challenge, again, you've heard from Florida, how do you go about arresting them? Most people had fled from Rwanda. They were everywhere else but Rwanda. So how do you go about arresting them? Closely connected to tracking and arresting fugitives was the issue of how do you go about overcoming political indifference. Again, you've heard it being said this morning from the former speakers and again from Florida, how many African countries and maybe even countries neighboring to Rwanda were completely complicit and uncooperative in apprehending suspects that had been earmarked for arrest based on various warrants of arrest that had been confirmed. The fourth is, how did we go about determining a realistic criteria to investigate gender-based crimes? Sadly, sexual assault on women was sadly a tool of the genocide against Tutsis. And it behoves on us, and it did as a tribunal, for us to determine, once we realize the sheer extent and the scale of those crimes, to determine a criteria of how we investigate and prosecute them. And I will speak to you very briefly as to some of the challenges that we encountered in so doing, and of course, with the help of Florida, who was in my team at the time, how we overcame some of those challenges, albeit belatedly in the day. The fifth challenge concerns procuring guilty pleas. And you might be shocked. Why would Charles be talking about procuring guilty pleas in the context of some of the worst crimes known to mankind? Well, for obvious reasons. Florida has alluded to 2 of them. The first is that the work of the tribunals were ad hoc in nature. We were limited in time. We couldn't just go on forever. Second, they were very expensive endeavors. I think I would not be far wrong in saying that it must have cost the international community well over $1 billion, in excess of $1 billion, the whole length of the life of the ICTR. Now, that's been extremely conservative. What is the practical effect of that? Well, the practical effect of that is that we had to determine other means of getting the work done. We just couldn't go on like that in perpetuity. So we were limited in time, we were ad hoc, we had our completion strategies set for us, and they were terribly expensive ventures, as you would hear in the course of the proceedings. The last challenge concerned the measures that we needed to take to expedite the process of trials, the process of making people accountable for violations of international criminal law. Why am I talking about that? Well, you've heard it being said, this concept of genocidal denial, this insane concept of a double genocide. Now let me tell you what the practical effect of that was for us. And everybody would sit down and criticize the ICT and say, it took us many years to get the job done. Well, it was very difficult to get the job done if the average defendant in court was coming there to deny the very existence of a genocide. What does that portend for us as prosecutors? It means everything is challenged. Everything is at stake. I have to prove that there were mass graves in a certain part of Rwanda. I have to excavate those mass graves. I have to call forensic scientists to indicate that the bodies in those mass graves belong to Tutsis from a certain region. They were killed on a certain day at a certain location by certain people. Do you know the sheer amount of time that goes into calling forensic experts, historical experts, to prove a fact, and then the defense get to call their own to challenge what you and I perhaps would think was an obvious fact? What that meant in practical terms for us was it just extended and overbroadened the scope of our trials. And that led to an inordinate delay in the work that we did. So if I pick some of these topics just briefly one after the other, how do you determine, let's go back to topic number one, how do you determine the persons who bear the greatest responsibility for genocide? Well, the sheer magnitude of what took place in Rwanda would have, at a minimum, suggested some level of acquiescence on the part of the state. And I'm picking my words very carefully here, all right? So genocides just don't happen just like that. And so when people talk about this crazy theory of a double genocide, one thing they forget, like Florida rightly pointed out, is that it's not possible to be spontaneous or random about a genocide. It just doesn't happen. It just doesn't happen. Genocides are planned, meticulously planned, for that matter. They just don't happen. Now, for us, even though we had earmarked the ringleaders as our targets, we had to weigh other criteria. What is the status of the offender? Because if we only go after ringleaders, we may not capture the totality of the alleged criminal conduct. So we looked at other things. The status of the offenders, were they political leaders, military leaders, the need for our indictments to be reflective of a geographical spread in the country. Because like Florida rightly told you this morning, there was only one genocide. There were not two genocides. It was one crime conducted over 100 days all over this country. One single crime. So that meant that the indictments and the prosecutions had to be reflective of the geographical spread in this country. Now, some of the issues were unique in the sense of the political issues involved. We had to consider those as well. The MRND party, some of the decisions they took. Florida talked about, and the moderator talked about, the inability to prove the crime of conspiracy. Well, the point is this: as prosecutors, your case is only as good as your evidence. That's what Florida was saying. So it's one thing for the propaganda out there to, oh yes, Bagasura did this, Bagasura did that. If we don't have the evidence indicative of Bagasura sitting in a room to plan this and that with other co-conspirators, that allegation in and of itself is dead on arrival. That's just how prosecutions work. What you need to be able to prove allegations such as conspiracies is what we call insider witnesses. Florida alluded to that. If you don't have the insider witness, there's got to be somebody in this room who's going to be willing to testify that Charles was here on the 17th of June speaking at this conference, without which you wouldn't be able to support an allegation of the things that I said. If we didn't have those kind of insider witnesses, for the most part, allegations such as conspiracy to commit genocide were simply not plausible. We charged them anyway, but would we succeed? No. So those are some of the challenges in deciding who did we go after. Then the thematic groups, which is the last thing I want to talk about. And I know we're going to be talking about religious leaders in the afternoon. Do we go after thematic groups? What are thematic groups? You've heard of the Butare case, the Kibuye case, the clergy case, which we didn't end up with the clergy, but we had the military, we had the political leaders, and we had the thematic groups along geographical locations. These were some of the decisions we made in the early days. But there was also one decision. The prosecutor at the time, Louise Arbour, had this Nuremberg image in her head. And she decided that she was going to have one single trial. You know, in Nuremberg, there weren't that many trials. One single trial involving the political brass, the military brass, and some of the militia leaders. 29 defendants in one courtroom, and charged them in a single indictment. The tribunal rejected that application. Why? Well, for obvious reasons. In an adversarial system of criminal justice, which is what the ICTR was operating in, how do you have 29 defendants in a single courtroom? How do you have 29 defense counsel? How do you have 29 co-defense counsel? How do you fit all of us into this room? Now, the practical effect, if you have a joint trial with 29 people in it, is that if I get a cold, I'm a defendant, and I have a cold, and I can't come to court, the trial stalls. No, nothing happens. Because it's an abuse of my fair trial rights that I am not present in court to listen to my own trial. So if one of those 29 people was unwell, that's it. So imagine how many times the 29 defendants will catch colds and headaches and diarrhea and all sorts of things. So it was practically impossible in an adversarial system of criminal justice to bang 29 defendants in one courtroom on a single indictment. It just wasn't plausible. These were some of the challenges that we realized. A lot has been said about earmarking suspects for arrest. I mean, we all know the role that countries have played, and we don't want to mention them because we're all lawyers and we all know who harbored who and who made it very difficult for us. But it's not unique to Rwanda. In Nigeria, we housed my government in Nigeria. We protected Charles Taylor for 3 years from the Special Tribunal for Sierra Leone. We granted him asylum, and he was free roaming around my country for 3 years, based on an agreement amongst members of the African Union and the international community that if Charles Taylor were taken away from Liberia and kept in a friendly country, it will calm things down. So that's what I mean about political indifference. We eventually surrendered him to the court after 3 years, but these are some of the examples of what I mean when I say overcoming the political indifference. Omar al-Bashir still sits somewhere in Sudan till today, and he visited Nigeria, visited South Africa, and visited Kenya. No one arrested him. Typical examples of overcoming political indifference. And I do agree with the moderator when she said that Antonio Kasese described international tribunals as giants without arms and legs. For the reasons we all know, we have no law enforcement powers of our own. So how do we enforce? Very quickly, talking about the challenges in prosecuting sexual violence. My experience at the ICTR made me realize very quickly that neither the existence of a strong political will or even the positive exercise of prosecutorial discretion in favor of gender crimes were sufficient to enable the successful prosecution of gender crimes, because there are many other things that we were confronted with. And I'll give you an example. One of which was the culture of silence. The culture of silence amongst victims of sexual violence. And this is not limited to Rwanda. It happens in Nigeria as well. And the culture of silence emanates from the fact that victims of sexual violence find it very difficult, very, very difficult to talk about their experiences, especially to men. Would it surprise you that it took us learning through the Muimana case how many women were so reluctant because we at the ICTL had sent male investigators to investigate sexual violence? Well, how many women do you know that would be willing to talk to a man about their sexual violence experience? It's difficult to talk to a woman, a fellow woman about it, talk less of a man. Those were some of the challenges that we learned, that dealing with trauma victims of sexual violence with a lot of sensitivity. You've heard of the cases of the judges who burst out laughing at the ICTR. They weren't laughing at the witness, by the way. They were laughing at the clumsiness of the defense counsel, who in an adversarial system of cross-examination, in a bid to impeach the testimony of a witness that has already been traumatized by multiple rapes, in a bid to impeach her testimony, thought he was trying to make her look most undesirable to the defendant. She had testified that she hadn't had her bath for several days because of the prevailing circumstances, and she was covered in human feces and all that. So he went and then said, so, you were covered, you were smelly, you haven't had your bath. Why would the defendant find you attractive to rape you? And the three judges burst out laughing. Now, mindful of the fact that they were not laughing at the witness, they were actually laughing at the question from our colleague who thought he was doing his work in an adversarial system. But that draws to our mind some of the difficulties and the challenges that we faced, both as prosecutors and as defense counsel, and as judges as well, in looking and prosecuting these crimes. The last challenge was in procuring and negotiating and obtaining guilty pleas. And I've told you why we needed those guilty pleas. These procedures were very expensive and they were limited in time. 76 defendants were tried by the ICTR. Hassan Jallo told you 61 of them were convicted. Of the 61 defendants that were convicted, only 9 of them pleaded guilty to various international crimes. I handled the guilty pleas of 3 of those 9. Ruta Ganira, Bisengimana, and Rugambarara. Now, the issue there is there were so many factors that affected our ability to obtain those guilty pleas. Just offering a discount on sentencing and saying, okay, if you plead guilty, we will reduce your sentence by this, was not enough. Why? Let me say this very quickly. Unlike the ICTY, the successes of the ICTR lay in the fact that the caliber of the defendants before the ICTR were such that it was not easy to convince them to plead guilty because they believed in this ideology. This sole ideology that has led to this issue and this nonsense of a double genocide being propagated all over the place. These people believe so strongly in this ideology that it was very difficult. But beyond that, they had lawyers that believed so strongly in this concept. I was here in April for the commemoration of the 30 years of the genocide. And I took a picture with Florida and the Minister of Justice in my hotel. And I posted it on my LinkedIn page, speaking about my experience of being back in Rwanda after 30 years and some of the genocide sites that I visited in Karongi. And one defense counsel, a Belgian guy, who I had known since my days at the ICTR, commented on my post in very strong terms and said, Charles, you know better than what you're saying, and this and that, and you know that there are two sides to the story, and this and that. And you know, this was a public post on my LinkedIn page, some defense guy from Belgium. And I wrote back in very simple terms, and I said, there is nothing more egregious than a genocide. The only thing that is more egregious than the occurrence of a genocide is the denial of it. It's the only thing, to my mind, that can be more egregious than the commission of a genocide, is for someone 30 years later to actually challenge me. And if you sit here in this room in the next half an hour, you will see why no one needs to be denying that a genocide occurred. I have taken much more than I intended to because I get carried away by these issues. Very, very carried away. So I allowed Tembili to have her time. I haven't answered half the questions, but let Tembili.
Yeah, thank you very much. Dr. Charles, I was wondering when you're making the presentation, given that the ICTR's mandate was limited to the high-profile perpetrators, can we say today that the purpose of sentencing was reached? The reason as to why I'm asking that question, there's one prominent advocate of retribution. He said that punishment is a right to criminals. So if you don't punish a criminal, you have denied them their right. So when you look at the sentencing regime of the ICTR, many of them have received imprisonment terms. But now at the moment, and some of them actually have benefited from early release. And some of them are now involved in genocide denial, which you're talking about. So should we say today that the purposes of punishment, sentencing, have been reached? Thank you. Maybe in 2 minutes, and then we
it's difficult, because, I mean, you know, the work, like everybody knows, the work we did was without precedent. And it was without precedent. And it's, in that sense, there was no statutory guideline in terms of sentencing. The judges developed the jurisprudence as we went along. And unlike genocide, which was codified, crimes against humanity was made up through customary international law. There is no codification for crimes against humanity. We have codification for genocide, we have codification for war crimes, the Geneva Conventions. But crimes against humanity had no codification. So judges made up this jurisprudence as we went along. And 30 years down the line, or 26 years of our work, it's looking more like there is some sort of codification to marry certain types of offenses. But that is taking 26 years. At the time, it didn't exist. We made it up as we went along. So have the sentences reflected the gravity of the offenses? Well, the only example I can give was that I was miffed at Pastor Ntakutu Romana getting 10 years because, according to the trial chamber, he played no active role in the attack at the Mugunero complex. Well, if a letter is written to you by your parishioners gathered in your parish and you take no active steps to prevent the attack on them, that's enough for me as complicity. But in determining the culpability of various defendants before the tribunal, the judges had to consider things like age of the perpetrator, whether his involvement was active or inactive, passive or not. And those are some of the considerations. I thought 10 years for a 79-year-old man. He wasn't too old to commit genocide, but he was too old to be punished. And some of my views on these things are very controversial, so please don't ask me questions like that.
Yeah.
I'm a Nigerian, you know, we get very worked up.
Yeah. Yes, thank you very much. Yes, Tembile, coming to you. Now that you're working with the International Residue Mechanism for Criminal Tribunals, do you think the legacy of the ICTR continued with the mechanism? Has it died with the ICTR or not? You can share with us the contributions, especially on the appeals cases.
Thank you very much, Charity. But before I answer your question, I'd like to take the opportunity to thank Certa Foundation and Rwanda Bar Association for inviting me to speak at this conference. So yes, the mechanism continues the legacy of the ICTR. You would know that the history behind the birth of the mechanism. Reference has been made to the fact that the Security Council mandated a completion strategy on the ICTR. When the Security Council made that decision, they placed it upon us. They just gave us deadlines and then left that completion possible. They said to us, finish all investigations by end of 2004. Finish all trials at first instance by the end of 2008. Finish all work, meaning appeals, by 2010. So those were the timelines that were set down for us. Then we had to sit down as the Office of the Prosecutor and the entire ICTR to decide how was it going to be possible for us to make these things possible. Amongst other things, identifying cases that can be transferred to national jurisdictions for trial, because it was not possible that we will conclude prosecutions of everything by end of 2008. Right? Part of the complexity was that investigations were at different stages. And for some of them, it was not possible that they would be concluded at the end of 2004 as expected by the Security Council. That's how come other cases now had to be earmarked for transfer to national jurisdictions, although some of those people had not yet even been arrested, right? Tough decisions had to be made for certain investigations to be suspended or just to be dissolved, because it was just not possible that we would be able to conclude them by December 2004. And certain things also had to be considered in there. For instance, do we even have information as to where this person is? Are there likely prospects of arrest in the next 2 months? And in situations where there was no sufficient information on the whereabouts of the suspects, where the information was not as ripe as to make it possible for us to arrest in the next 2 months or so, we had to suspend those investigations. The fact that the ICTR had to come to a difficult decision of suspending investigations did not mean that those persons were suddenly free of accountability. And this is where the mechanism comes in presently, particularly the Office of the Prosecutor. To assist the Rwanda prosecution authorities to find these persons and make sure that there is accountability in the first phase. In the second phase, to continue cooperation with other countries where these people are known to be, for those countries to either prosecute, to either extradite to Rwanda or to prosecute in those countries. So that is part of what the mechanism is doing, because part of, the biggest part of its mandate is assistance to national jurisdictions. National jurisdictions have the responsibility to investigate and to prosecute. And in cases where they have reason to believe they have to investigate or prosecute somebody, they look to the mechanism, for the mechanism to provide whatever information we have that will assist in their investigation and prosecution. Aside from assistance to national jurisdictions, the statute of the mechanism gives it power to investigate and prosecute cases of interference with the administration of justice. How is it relevant? How is this relevant to continuing the mandate of the ICTR? It's relevant because it helps to preserve the history that the ICTR laid down in the last 20 years before it closed in 2015. A number of people were found guilty at the ICTR. Judgments are there, judgments speak for themselves. But in the last 2 years following the completion of the ICTR's mandate, we see a trend in which witnesses are being interfered with by the friends, the relatives, the sympathizers of the convicted persons to say, can you please write a letter and inform the judges of the mechanism that you actually lied when you testified at the ICTR. They give them money, they intimidate them, they do all sorts of things. These people are vulnerable. They then agree, for the right or the wrong reasons. We don't know what kind of pressure they are subjected to. They now write letters in which they recount their evidence. And if the statute of the mechanism had not created this power for us to investigate and prosecute cases of interference with the administration of justice, that would undo and actually change the history as it was laid down by the ICTR in all these cases. Because you now have people coming forward to say, oh, it was a lie, I actually didn't see that person, I was put under pressure by the prosecution to go and testify falsely. And I'm proud to say in 2018, we successfully got a confirmation of indictment against 6 persons who were busy in Rwanda running a recantation scheme on witnesses who had testified in a case of somebody who had just been convicted and was still in Arusha before being transferred to go serve his sentence in a different country. Thanks to the cooperation by the Rwandan authorities, we were able to gather evidence that allowed us to reject the review application by this convicted person and thereafter successfully prosecute all the 6 of them for contempt for administration of justice violations, because that is contempt of court under the rules. There were 6 accused persons, 1 died before conclusion of trial, 4 were convicted, 1 was acquitted. We did not give up. We appealed the acquittal of the defense investigator, and the appeals chamber agreed with us that he also has to be convicted. That was point number 1. Point number 2 on appeal, the convicted person himself, he was also part of this scheme. Hence, he was joined in the case being one of the 6 persons. They found him guilty. However, in the sentence, they ordered that his 2-year sentence should run concurrently with his genocide conviction. We went to the appeals chamber. We said, no, this is an entirely new crime, which actually seeks to undo the record of the previous case. It's a completely new case. It's got nothing to do with his genocide conviction. And we pleaded with the appeals chamber to order that the 2-year sentence has to run consecutive with his genocide conviction. So he is in a country where he's serving his sentence. He's just at the beginning of his genocide conviction sentence. As soon as he finishes it, he is going to serve his 2-year sentence for for contempt of court. So these are the two ways in which I can say that the mechanism is doing its best, I can say, to continue the legacy of the ICTR. Thank you.
Thank you very much for that presentation. It was actually clear, precise, and concise, telling us more about the contribution of the residue mechanism. And I think it was clear to everyone in the audience. But just one last question, and I give you maybe 1 minute to respond to it, not to be like one of the East African leaders who traveled to Europe for 8 hours, and then they gave him 15 minutes and said, how can I travel for 8 hours and you give me 15 minutes?
15 minutes.
But at least for you from Arusha, so it's not so many hours.
It was short.
Yes. So I know you have worked with the African Court for Human and People's Rights, and also given your experience working at the mechanism, what is the intersection between human rights and international criminal justice? Are they in conflict? Thank you. In 2 minutes.
I wouldn't say they are in conflict. I would actually say they are complementary, because international criminal law is aimed at punishing acts which affect fundamental human rights. Mm-hmm. For instance, the right to life, the right to liberty. Those are rights that are protected for every individual, but then international criminal justice also has mechanisms of making those rights wrong, those wrongs right, in terms of criminalizing acts which are at the same time violations of human rights. So I see the two as being complementary.
Okay. Thank you very much. Can we again give a round of applause to our panelists? Yes, as we are coming to the end of this panel discussion, allow me just have one question from the audience, and then we close off the panel, especially from the students. If there's no question, then that is okay. Okay, thank you. At least there will not be any claim that I did not give time for the audience. So, yes.
Sorry, there was, because I was trying to give time to 10 minutes. The second part of your question about the precedent and the example you gave, it's just to say that in terms of the work that we did, and there being no precedent, one of the things that the people in this room have to understand, as was obvious from Hassan Jallo's comment of the Security Council at the time the tribunal was presenting its last case and being closed, the ICTR, unlike any other international court, is the genocide court. There is no other court in this world. There is no other court in this world that has the experience and the jurisprudence in relation to the crime of genocide. Because the crime is so rare in its occurrence. I am currently before the International Court of Justice on behalf of an African state, seeking to intervene in 3 matters that have been taken there: the Gambia versus Myanmar, South Africa versus Israel, Nicaragua versus Israel. And our interest in those cases only concerns our right as a contracting party to the Genocide Convention as to the interpretation of what constitutes genocidal intent. Because genocide is the only crime known to mankind that requires that specific intent. It is not the act that makes it a genocide. It is the targeting of members of a group identified as such that makes it a genocide. And that is unique to the crime of genocide. You've seen how the international community has refrained from calling what's going on in the Middle East a genocide. There's a reason for it. So, in terms of your question, the precedent is still being developed as to 2 things. What constitutes the special intent for genocide? Because it can only be inferred from conduct. There is no statute that tells you this is what constitutes genocidal intent. It can only be inferred from conduct. And that jurisprudence is being enhanced. The other part that is being enhanced is in relation to what is the duty to prevent and punish the occurrence of a genocide. Again, that jurisprudence emerges from the Rwanda Tribunal, and it is still being developed before the International Court of Justice as I speak here today, as to what are the obligations of contracting parties to the Genocide Convention to prevent or punish the crime of genocide. I just thought I'll add that. Thank you.
Thank you very much. As we come to the end of our panel discussions, allow me to appreciate each of the panelists for their contributions. It was really informative, insightful, educative, and not just for now. I know we need to appreciate you for your contribution in the development of international criminal justice, because all of you have worked at the ICTR, also in domestic jurisdictions. And the audience will agree with me that today we have gained a deeper understanding of the dynamics, the complexities that are involved in international criminal justice, specifically in investigations, tracking, arresting, and prosecuting international genocide fugitives, but specifically with a reflection of the work of the ICTR. Thank you very much once again. May God bless you.
Thank you so much, Dr. Charity, the moderator of this panel discussion that you have just ended, and you have made a brief of the takeaways. Thank you for that, and I'm not going to repeat that. So in the interest of time, I'll straightforward proceed with the next item on the agenda, and I guess the media team is ready. We have the film screening on the Certa Foundation documentary journey. Just 25 minutes.
Children. Yeah. Here there were, what, 7,000 people? And yeah, well, both here in Kwibuka. High concentration of children. It's amazing how they've been able to preserve a lot of this from the refugees. I'm not even so sure if we used this during the trial, right? I don't think we may have had photographic images of it, of them. But whether or not we actually, I don't think we actually brought the physical. I mean, by that time, judicial notice had been taken of the fact that genocide did occur throughout Rwanda. So we were absolved from.
Some of this would have been used as aggravating factors just during sentencing. How many children, example, victims?
bodies?
Yeah,
Where do they get this from?
around here.
They find them when, oh my God. So they just, these are recent, and this clothes. Oh, wow. Wait, where? Oh, wow. So they just found these bodies? This is
Among the reason box you see here, two, they recognize their names. Yeah, others they found during when they are during the preparation of land.
So these were in shallow graves. Yeah, obviously they were in shallow graves. They're still finding bodies in 30 years after. So you don't know where the bodies were buried. So they're just finding it now. So eventually they're still going to bury these bodies, right? They will have to. Or put them in the The last time I saw this was in 1998, when we first started this work, and we had to excavate all the bodies from the mass graves, and to think that 30 years on, they're still finding remains in shallow graves. Wow. Incredible. This is. I'm standing here at the Kwibuka Catholic Church 30 years after the genocide and 26 years after I started coming to Kwibuka as an investigator and prosecutor. 26 years. The first time I set my foot in Kwibuka was in 1998, January. And I'm thinking, mass grave still being uncovered in 2024, April, 30 years after the genocide. So really? Seriously? But you know, as I took that all in, there's an element of guilt that's set in. Deep guilt. And I'm thinking, wait a minute. I cut a guilty plea deal with the major assailant, the man who was suspected to be the brain behind the killings at this location, a man called Vincent Rutaganira, the concierge of Kwibuka. I cut a deal with him and recommended that he be sentenced to between 6 and 8 years. And he was sentenced to 6 years. And I'm thinking, and bodies are still being recovered from this same site 30 years after the fact? Really?
Around when Charles was trying to be practical and saying, listen, we need, we've done a lot of cases, we've won a lot of cases, now we need to plead some of these people out. And I remember, fighting him tooth and nail and saying, you don't know what they did. You cannot do a plea agreement that has less acts that they did when we have evidence that they did a lot worse, and then you're trying to give them a lenient sentence when we can actually get life. And so we fought and fought in Charles's office, and for probably the 100th time, voices raised. I ended up, literally storming out of Charles's office and banging his door, having told him that, listen, you're doing this, I'm not part of it, I'm not putting my name on these cases. And him going like, you know what, why is this so personal to you? And I said, why wouldn't it be personal? And I remember screaming at him, it should be personal to you too. Because, the things that this man is accused of doing are not your everyday crimes. But living in Uganda, truly, we were never comfortable because every day you were told, even as a kid going to primary school, that you're a tiny Rwandan kid, go back home. So I remember vividly my sister was much younger than me, going to kindergarten and coming back crying and saying, you know what, I don't want to go back to school. And I asked her, why are you crying? She says, oh, the other kids are saying, my eyes are too big, my nose is too small, I'm Rwandan, what do they mean? And so we grew up with a sense of not belonging, with our parents and our uncles and families telling us, listen, you have a country called Rwanda and we'll go there someday. And we were taught, how to speak the language, even in exile, and how to be self-aware that someday we'll go back home to that country. And I kept asking, why can't we go back to that country? And we were told that the regime that is in Rwanda doesn't want us to go back home. So somehow, as I was growing up, I was made aware of the fact that, well, there's a possibility that we can go back home, but at the same time, we are not allowed to go back home, which was, to me, a huge contradiction. But everywhere I went, in schools, in high school, in primary school, I always used to be very clear to everyone that I'm Rwandan, which was a bit strange because some of my peers, in fact, used to, pretend to be Ugandan, pretend to be from certain tribes in Uganda, which physically kind of looked like us. So as a young child, you're always thinking, what am I going to be in future? I remember though one time we went to a place by the border with Rwanda, where my uncle was getting married. So we went to do the traditional wedding ceremony called Gusaba of the bride, and they lived right close by the border. So my uncle and his friends and all of us, we were going up the hill, going to that home. And I remember the older people telling us, you know what, look, those hills are in Rwanda. And as young kids, I think it was maybe 1989 or perhaps 1990 at the beginning. And I remember the excitement of seeing, hills that are said to be in this amazing country where we belong, that we had never been. So when you're growing up, you indeed, start wondering, what am I going to be career-wise? What am I focusing on in my studies? And I really, really honestly thought I was going to be a journalist. That was my ambition. And then 1994 happened. So I was in secondary school, in the 4th year of secondary school. I was in an all-girls boarding school in Kampala. And, you know, we started reading. I used to read newspapers a lot and watch the news. And then we started seeing bodies floating down the river, people getting killed. And every Wednesday, we used to walk up the hill to go to a Catholic cathedral to pray, and people would give in their prayer requests. And obviously, the few of us who identified as Rwandans, our prayers were always praying for people in Rwanda, you know, who are victims of the genocide, to be protected. And that went on for months. Our Ugandan friends, you know, started saying, oh, now we can't eat fish because the fish are too big. They've eaten the Rwandans, the water. And then, you know, the Rwandan community in Uganda started organizing themselves to go and bury the bodies that were streaming down the lake or river from Rwanda. And so at that point, I just made a vow that I'm going to do everything to bring the culprits to answer for what they've done. I felt helpless, just like many Rwandans. And then I thought to myself, what can I do to make sure that whoever is responsible actually pays what they've done.
International courts and tribunals are established for victims and not for the yearnings of the international community. Once we understand that the very premise of an international court is not for the yearnings of anybody sitting at New York headquarters. It's for the victims. And if you understand the accountability process, then it very quickly occurs to you that the court or the mechanism or the structure has to be situated to the extent feasible at the location where those crimes are committed. That, for me personally, in spite of all the work that we did, and in spite of all the attempts by the international community to establish some outreach, I think that is the only drawback. If I had to do it all over again, I would have situated the ICTR right here in Rwanda. And when I look back now and I say to my friends, my Rwandan friends, okay, so how much of what we did? Okay, so it's bad enough that they didn't follow the process. All right, so we now have a very robust archiving system. How much of what we did, these 12 cases and this 12 defendants that I convicted for the worst crime known to mankind, how much of what I did is available to the average Rwandan? The response I get is not positive enough for me. And I look forward to a situation where students of history can walk into a location and research the kind of work that I did. On behalf of the victims of the most heinous crime known to mankind. So study it, watch the videos, read the transcripts, read the judgments, read my I still have access to my own closing arguments. I'm reading my own closing arguments and I'm still learning. I'm thinking, oh my God, we did a lot of work. So the long and short of it is that the information exists. All right, the information is out there. I hope, and I hope to God that through some mechanism, whether officially sponsored through government or NGO sponsored through philanthropists, there is going to be some mechanism for people to have access to the very important work that we did, because that work is still relevant and valid today.
Lights on. To understand the making of this documentary and actually pose a few questions about its making, we are going to have a brief panel discussion to be made by Dr. Charles, whom you have seen throughout the documentary. I will take the privilege of not introducing him again since the bio has not changed. Ms. Florida Kabasinga will join the panel as well, and I will not introduce her again. She's introduced, and I'll now proceed with the introduction of the panel moderator, Benita Uruhisho, who is a multilingual professional with a vast background in international organizations, specializing in community empowerment, gender equality, and access to justice. Currently, she's serving as the head of partnerships and communication at Certa Foundation in Kigali. And Benita excels in identifying and engaging strategic partnerships globally and locally. Her expertise includes developing and implementing communication strategies, managing stakeholder relations, and spearheading advocacy efforts to promote rights and visibility for marginalized communities. Prior to her current role, Benita was a liaison officer at the Canadian Bar Association in Ottawa, where she managed volunteers, coordinated projects, and facilitated communications between legal professionals and advocacy groups. She also served as a program officer at the Bill and Melinda Gates Foundation, driving initiatives to enhance workforce development and the strategic engagement with industry stakeholders and government bodies. Welcome on the stage, Benita. She'll be joined by Isobel Akwa. Isobel Akwa is the director for law and innovation at Certa Foundation. Isobel is a dual qualified transactions and corporate advisory lawyer with experience in investment banking, venture capital. She is a multilingual professional with over 20 years of legal and business experience across a number of jurisdictions in Europe, Asia, the Middle East, and Africa. Her previous work experience includes the financing of assets, corporate jets, marine assets and technology, debt and equity transactions, preparing tech-enabled SMEs for investment, and providing strategic structuring solutions to corporate clients. She has worked with the financial actors, tech startups, and large corporations to provide legal and operational oversight, corporate and board governance, transactional management, and due diligence support for foreign investors. She is a product of Bank of America, Merrill Lynch, UK, US, CMS, Cameroon, McKenna Law, UK, Belgium, the Whitaker Group from Ghana, AB and David Law, Ghana and US, Yellow Capital in Ghana, and Global Trotters Legal Africa, Ghana and Senegal. Isobel is a passionate gender and youth advocate. She's a founding member of the Ghana chapter of the International Women Forum, a global network spanning 33 countries with a common mission of advancing women's leadership and championing equality worldwide. She founded the Lady Initiative in Ghana, which has impacted over 300 young women, and co-founded the Pearl Safe Haven, which is focused on advocating for and rehabilitating survivors of gender-based violence. As a youth advocate and diversity champion, Isobel worked with Bank of America, Merrill Lynch, UK, to design and implement their Africa internship program and provide training to interns and university-aged students. She was appointed to the inaugural Governing Council of YALI West Africa, funded by the United States Agency for International Development, USAID, and the MasterCard Foundation, which oversaw the dramatic transformation of more than 4,000 young Africans, including women identified through CAMFED. She's a champion for youth leadership in Africa and facilitates capacity building sessions for students and young entrepreneurs in partnership with UNFPA Ghana, Athes University in Ghana, University of Legon, Ghana, and the African Leadership University in Rwanda. Finally, Isobel holds a bachelor's degree in law from University College London, UK, with German law experience from the University of Cologne, and a master's in intercultural communication from Birkbeck University, UK. She's qualified to practice law in England and Ghana. A round of applause for Isobel. The next speaker is Philippe Nyirimihigo. Are they there? Philippe Nyirimihigo. Philippe is an accomplished visual content producer and art director with over 15 years of experience bringing impactful stories to life. As co-founder and director of visual content at Urium Limited, he has led major photography and video campaigns for prestigious clients like Google, Meta, MasterCard Foundation, FIFA, Kevin Hart, for Visit Rwanda, and the World Bank, to name a few. Known for his keen eye, Philippe produces captivating storytelling content that resonates with the target audiences. He is a collaborative team player who manages projects skillfully from a start to finish, exceeding expectations and building strong partnerships. Passionate about elevating brands, organizations, and even individuals through storytelling, Philippe is a creative force dedicated to delivering exceptional results. He brings his expertise in visual storytelling, project management, and strategic planning to every project. A round of applause for Philippe. Lastly, Christia Kaiteshonga. Christia Kaiteshonga is the founder and filmmaker of CK Art Productions, a company that specializes in creating cinematic experiences that empower brands and individuals to communicate their messages effectively. With over 10 years of experience in the film and entertainment industry, he holds a Bachelor's of Science in Film Science from Full Sail University. Christia's passion is to craft films that stand the test of time, blending his skills in storytelling excellence, cinematic mastery, and evergreen content creation. He has collaborated with many well-known artists such as Erykah Badu, Charlemagne the God, Jane McGarry, and Kevin Hart, and has supported various non-profit organizations in raising funds and awareness for their causes. Christian's vision and creativity have earned him a reputation as a skilled and innovative filmmaker, and he continues to inspire and impact the film industry and beyond. Ladies and gentlemen, join us for this panel, and I hand over to Benita.
Thank you so much. Good afternoon, everybody. What an honor to be on this panel with you guys. And also just watching that documentary brings back so many memories of how the conversation started and we all took a crazy road trip to Kibuye. So I will begin with Madame Florida. What inspired you to spearhead the creation of this documentary, and what impact do you hope that it will have on the global understanding of the 1994 genocide against the Tutsi?
Thank you, Benita. I think it hit me that it's 30 years since the genocide happened. I don't know, for some reason, this particular year has been a bit difficult and very emotional, just because the work that we did as prosecutors at the ICTR, I don't think many people know what it took, how tough it was, what was involved, and how difficult and impactful what we saw left a mark on us. And I think, as the years pass by, a lot of people forget how horrible what happened in this country was. And I thought, it's high time that we told these stories so that the next generations and people in the international community will know what happened here and the work that was done, not just by the tribunal, but also by the domestic judicial systems in Rwanda in trying to bring justice to the victims. So for some reason, I spent a couple of weeks really unable to get it out of my mind. And then I thought the only way we can tell these stories is a lot of people don't read.
Yeah.
So when you talk about Rwanda, a lot of people, the first thing they will tell you is Hotel Rwanda, which is fiction. So I thought, you know what, the real stories of Rwanda need to start being told visually and in writing. And I thought this was the right moment to start doing that. And I thought doing it with a group of very dedicated people, a group of people that have the expertise to do this, who are young Rwandans, will contribute to passing on knowledge, not just to them that are involved directly, but to people that will see it. I thought, they would make justice to the story. And it's only just the beginning. I think the foundation has dedicated and decided that we are going to tell these stories. As Charles said in the documentary, when you look at the archives of the ICTR and other archives about the genocide, they are somewhere sitting down in places that people don't have access to. But if you do a documentary and disseminate it widely, a lot of people will watch it. And for me, that was the motivation. And I can already see this is the beginning of the journey. We are yet to conduct other interviews, but I think it's going to be an impactful contribution to the preservation of memory of what happened in this country.
Thank you so much, Florida. Thank you so much, Florida, and definitely for spearheading this so that future generations can have stories that they can watch. Dr. Charles, I know this is the first time you see it today, and I'm eager to hear your reaction. It was a heavy-filled 3 days when we went to Kwibuka, so just walk us through the process, how it was when you came to Kigali, and I'm sure Florida gave you a call to go to the sites. Why was this important for you to tell these stories? And also, what was your reaction when you saw it today?
Thank you. Let me give some background to my relationship with Florida. When I first met Florida, I was leading the prosecution of the Intakitu Romana joint trial. It was the same year September 11 happened. It was 2001. And Florida was still studying at Makerere University and had come to the tribunal as an intern. And she had been assigned to my trial team. And then after that, she went back to Makerere to finish her undergraduate studies and proceeded to do her postgraduate studies in the United States. But we always kept in touch because of her passion for the work that we did, as is evident from what she said in the documentary. But also because at the time, there were not that many native Rwandan citizens who were taking an active part in the prosecution work. Whether it was a deliberate policy or not, I'm not sure. But we had that knowledge gap. And one of my successes at the ICTR in the coming years was because I had the privilege of having a native Rwandan embedded in my team. And I had that heads up against what was prevailing in other trial teams because she was in my team when she eventually came back and we co-opted her into our team. We had some sort of bird's eye view of some of the cultural nuances. And even I remember in court, when something is said and she's not happy with the translation, she will send me a note and she said, Charles, that's not what the witness said. And I would jump up and object in court, and I'm like, and the judges be looking at me thinking, well, you don't speak Rwanda. How do you know what the witness said? I'm like, yeah, I've got somebody behind me that speaks. So we go back a long way. And when I did my stint and did my 12 trials and spent 12 and a half years, I left her at the ICTR. And in the coming years, when she then left the ICTR, I encouraged her to let us write. And Florida would, oh, let's write. And I've since written I've contributed to 2 books. And I always try to get Florida involved. And she would be like, oh, don't worry, I have a plan. I have a plan. Okay? You have a plan. So for many years, I didn't know what that plan was until this year. And, you know, she just very casually said it. 30 years anniversary of the genocide. Charles, there's something I'm working on. And I'm like, yeah, right? Are we writing? No, it's not. It's better than that. We're going to do a documentary, and we're going back to Kwibuka. We are? Yeah, with a film crew. I'm like, seriously? Anyway, the rest, as they say, is history. I made myself available in April at Florida's request. What I thought would be a speaking engagement in Kigali ended up being a 2-3 day sojourn into Kwibuka, Karunji, where I hadn't been. I think the last time I visited Kwibuka was 2005 or something like that. And it was, first I was excited about going back. But I was even more excited to have the opportunity to meet with some of our witnesses, some of the witnesses who had testified. There's something I need to clarify about what Florida, what happened in the documentary. Vincent Rutaganira, and yes, I do feel very guilty about that. But I'll tell you why we needed to negotiate that guilty plea. Vincent Rutaganira was the last. We had a joint indictment called the Kwibuka indictment. It was the very first indictment to be confirmed at the ICTR. It was a joint indictment of 8 people, 8 defendants. And we, over the years, had severed several defendants from that indictment and tried them as single accused cases. Kayeshima, Ruzindana, I think Indi Dabahizi, and so many others. We've been very successful with the Kwibuka indictments, which I led as senior trial attorney. And Rutaganira one day just walked into the tribunal and surrendered himself. 2 things happened at that time. We had the completion strategy, as Tembili rightly pointed out. This completion strategy meant we needed to close shop. We'd been very successful with all the Kwibuka cases. I think we had about 6 or 7 defendants having been convicted to life sentences. But then, because of all the witnesses that had been called in the Kwibuka cases over and over and over again, we were suffering witness fatigue. And your case as a prosecutor is only as good as your evidence. Having weighed all those factors, we decided to take the plea offer that he was offering. He was the last man standing. We didn't have many witnesses that were willing to implicate him. A lot of our witnesses had been discredited as part of this adversarial process. So we literally just went with what we had. So going back to the field this year and being confronted with that scene that you saw, naturally, I'm thinking, this is the same site that I literally let Mr. Rutaganira off for, just with a slap on the wrist, really. And just being confronted with that just really made me feel terrible.
Thank you so much, Dr. Charles. Thank you so much. I will now speak to the director, Mr. Philippe. You've been directing this documentary. Could you please walk us through the creative process of bringing this to life?
Thank you. First, I think I want to thank Florida and her team at Certa Foundation. What we don't realize is by bringing the creatives on the table, you're truly making the story as sort of as accurate as possible. So I want to thank you for that, because that was a huge phone call to get that call. And it's one of those opportunities when they come along, you know you're about to do something historical. And I remember, like Dr. Charles was saying, or even Florida was saying, when we were younger, without knowing much or limited understanding of our history, we thought Hotel Rwanda was the truth. And we'd even tell our friends, oh, you know, they ask, where are you from? I say, Rwanda. Have you seen Hotel Rwanda? Yeah. And that was a basis of sort of starting a conversation, which in hindsight was terrible. And so when we get the call from Florida and her team to work on something as impactful as this, a documentary is not fiction. A documentary is based on facts. A documentary is based on truth. Like you saw, the scene where Dr. Charles, we were all there, where we come across those remains being cleaned, that is not staged. That is a real moment that shocks so many of us, even on the team, so much so that actually half the team kind of stayed behind. Yeah, and they could not process what was happening. So what you're getting is a raw emotion of Dr. Charles, of all of us coming to this reality. And the beauty of, you're asking about sort of the creative process, is the beauty of a documentary is that you can't take that away from people. Fictional, you can have characters, you can, as we know, Hotel Rwanda is terribly inaccurate, but the documentary is there, it's facts, it's things that we saw with our own eyes. So that has been quite an incredible journey to be part of. The second thing I would say is Florida's insistence on using or working and collaborating and partnering with the Rwandan creative industry is really huge. Us sitting here on a panel, us being at the table, really matters in bringing this story to life in a very, whether it's nuanced or especially authentic. The authenticity of the story matters. Being told by Rwandans, for the world does matter. So it is not done on us that this is a huge moment. I think if we look at some of the statistics and what we're trying to build towards is when you have platforms like, let's say, DSTV that have something like 5 million subscribers, when you have YouTube channels that are watched by 30 billion people all over the world, when you have Netflix that has 220 million subscribers, these are the places where we hope this documentary will appear on, because what you do is you're helping tell that story from an authentic voice for us to the world, so that we can counter some of these things that were talked about earlier, denial. So yeah, it's been a great pleasure and an interesting ride, to say the least.
Thank you so much, Philippe. Since you mentioned the bodies that we saw when we were in Kibuye, I'm very eager to hear from Chris. Since he was the one, holding the camera, some of us had the privilege to step back, and we actually did not see anything, and seeing it on screen was the first time for me, and I kept closing my eyes. So can you walk us through your thought process as you're holding the camera, because nobody was expecting that, and you were getting so close to the bodies and their washing. How did you hold it? How did you manage?
It starts to freak me out, even just sort of looking back at it. But thank you, Benita. Like Philippe just said, this was not rigged at all. This was not planned. We were doing a visit, and Dr. Charles was just done going around the church, and then he was like, let's go around the memorial site so I could take a look at it too. I could take a peek at it. And then we had another camera operator, Alan, was operating the camera, and something within me just had me snatch the camera out of his hands to just run with Dr. Charles and just take in the story. And then coming around, I hear him start to speak because I'm all zoned in into the camera. And I'm like, whoa, don't look away, just focus on him. And so coming close to the remains and you know, just hearing him from, it's like a bubble. You tend to fall into a bubble where you're just like stuck and you're like, wait a minute, do I believe what I'm seeing? How do I act? How do I react? At the same time, I have to continue to be professional and do this job. Am I angry? You know, there's so many emotions that just overcloud your mind, and just seeing that for me was one traumatic. And on the drive back, I think to the hotel, I was just talking to myself, and it could show. I think Florida was filming with her phone. It could show, but I was just speaking to myself, and I kept wondering, because the thing was, it's been 30 years. And you're looking at it, you're like, it's 30 years and we're still finding remains. And someone has the audacity to stand anywhere in the world and say, you know, there was a double genocide, or there's all sorts of things that are being talked about. And it's just so hard to believe. Which to me personally, again, like, I'm really grateful to Florida and Benita. Benita made the whole connection. I'm really grateful because in hindsight, I went to school initially to become an architect, and then a full scholarship was granted to me by the people who didn't even know me to go study film, because I had used the camera for a little bit. And then I just immersed myself because it was exciting to study something where I know I could play with images. And then mid my journey into school, I think they showed a documentary of, they were talking about a picture. I don't know how many of you have seen this, but it's a picture of a little child, and I don't know where exactly it is, but there's a vulture and a hungry African, it's Ethiopia, and a hungry African child sitting down. And part of the classes that we're taking was that photograph, and how the photographer ended up committing suicide because he couldn't go back and help, and instead publicized the picture. And that changed my whole perspective of why exactly I was studying film, and sort of an understanding of why this scholarship had come to me. Again, it was granted by people I'd never met in my life. And that just set me up to understanding the craft so well, and knowing that eventually I'll come back home and be able to collaborate with the people here to tell our story. The biggest complaint was the technicality of how to tell these stories. So I focused on becoming a cinematographer, knowing how to set up lights, knowing how to operate a camera, and knowing how to explain emotion in a frame. Which takes me back to the remains, is just me sitting down there with the remains and just really taking that in, and I hope that, you know, is what comes out to the audience as well. And then being back, you know, this is, I don't know, many years ago, and being back here and meeting Florida and saying, we need to tell these stories, and understanding and giving us the trust to say, you're the creatives, I'm ready to tell the story. And I'm gonna invite Dr. Charles and everybody else that was part of this. We're gonna let you guys craft the story for us. For me, right now is like a full circle where it's, I was just telling Philippe earlier this morning, I was like, I can't believe we're doing this. But for me, it means so much that as Rwandans, we're starting to tell these stories on our own, and to the global standard of what technicality might be, because that's attractive also on its side. But being able to do that and being able to sit here and showcase this, I'm so excited to see where this is going to go.
Thank you so much, Chris. Ms. Isabel, you've been here from the beginning. At Certa Foundation, Florida comes with ideas and we bring them to life. Could you describe to the audience what it's been like as a non-Rwandan to be on this journey with us, and what message do you hope that this documentary will send to viewers around the world, especially in terms of legal justice and human rights?
Thank you so much. I think for me, I grew up in Vienna, in Austria, which is really, with Germany, this real center about history of war. We really honor war, we know war, etc. And like Florida, I was a teen as well when the genocide started. But I was a teen in Austria where we also had the Bosnia War. And I remember at that time, we were so inundated with, messages of war. We were creating boxes to send to people in Bosnia, and there's so much attention. And yet when the Rwanda genocide started, it was almost like the 5 black kids in the school decided to make noise about it. And I remember we hosted an event. We got all of our parents to cook food, and we forced the administration to recognize what was happening in Rwanda, because it was always about Bosnia, but there was nothing, when April 1994 happened. And so I've always felt this sort of strange connection to this country and to the history, and I think it was just a weird season, because you're this teen, you don't understand really what's happening. And I think, like my fellow panelists have said, eventually Hotel Rwanda came out, and we thought, oh, we got the story, we made everybody watch it. And yet when I moved here and went on this journey with this group, I just realized how Eurocentric our history telling is. The Bosnian War, which was so well documented, is only a 1/10 of actually what happened, that we are aware of what happened in Rwanda. And so I think it's so important to tell the story. I think just going on the journey with them and really going as an outsider with a real passion and a love for this country, but really as an outsider, I realized how much worse it was than the worst imagination I had of what actually happened here. I think standing at the church before we even, came across the remains, which was very shocking in itself, just again, as I think Philippe and Dr. Charles were saying, just coming across like, how do we still have remains after 30 years? But for me personally, when we went into the church, it was such a beautiful, peaceful, very, very quiet, just that serene feel. And then Florida and Dr. Charles started telling me what had happened in the church. And there's just trying to juxtapose just the serene, peaceful church with rape and crime and children seeking refuge and the role of church leaders. It was very hard to stomach. It was a very, very difficult day, because I think as third-party, individuals, as an African myself, it is, it's incumbent on us to tell the story properly. It's incumbent on us to, and Dr. Charles was saying this, in the earlier panel, and even in the documentary, there is no other really recognized genocide trial or court. The 1948 Act, the 1948 Genocide Convention, came as a result of everything that happened in the Second World War. So again, going back to Austria, we know all of these things, we've studied them, but we didn't use the 1948 Convention at the Nuremberg trials. They came afterwards. And so beyond just really recognizing what actually happened here and telling the story from an authentic way, it's also important that we actually steward the judgment, steward what actually happened, appreciate that this is where we set precedents in international criminal law, and recognize this is not just a small country with a personal issue. This is an incredible, important part of history that needs to be documented properly, that needs to be studied properly, that needs to be disseminated properly. And so it was an absolute honor to be part of the team and just to learn from them and really just spend time with because I work with Florida in a completely different capacity, right? So we do a lot of stuff and working with young people and women and tech startups, et cetera. And so this was an incredible time to see her in her real, this is really what brought her into the legal arena, and to just spend time with her with that different approach, and with Dr. Charles and Benita, but also with Chris and Philippe, who are really incredible stewards of this story. And I think it really is important that you have this younger generation of Rwandans. It's a healing process for them as well, because they have been told glimpses of story from their own personal histories, from their families, and even just watching how they were learning things about their own country was really fascinating for me. So thank you so much. It really has been an absolute honor, and I know there's so much more to come on this, and I know this is going to be an incredible, impactful documentary, because it doesn't just tell the story of Rwanda's history, it also really points to the resilience of a people to build a nation that we see today within 30 years, and also will stand as a testament, for all the other wars and genocides and conflicts that we're witnessing today.
Thank you so much, Isabel. In an effort to keep time, I realize we all have to go to lunch, so I'll do the closing question for each person, and we'll go from here. Ms. Florida, how do you see this documentary contributing to future legal frameworks and justice systems in dealing with crimes against humanity?
First of all, before I answer your question, and in fact, in answering your question, I want to give anecdotes of what happened during this journey that we have been on for a couple of months now. Initially, when Philippe came to see us in the office, I just told him a few things that happened at the ICTR, and he was trying to disappear into his chair. He was so horrified, and he lives in this country, and he has heard stories of what happened in this country, but he was still horrified. And that happened every single time we met. And I remember when we came from the massacre sites with Chris, he was sitting in the van, and I took my phone out and started taking a video of him, and you could see what was going on in his mind. He was so horrified. I don't think, so when we went back to the hotel, we met some people that were with us, but that hadn't come to the sites. They looked at our reactions, especially Chris and Philippe, because Charles and I were already, we have been traumatized for years. So for us, and then some of these people asked them, they said, did you just see killings that have just happened? But the point of the whole thing is you can never, ever get used to this horror of what happened. So if even us who are close in generation to what happened in this country cannot wrap our minds around it, how can we expect generations that are coming 40 years down the road to actually try and wrap their minds around it? So I think it's imperative that we tell these stories now. And when you start documenting things quite late, memory, you start, forgetting things, and, the stories and the history dies with the people that know this information. We had that challenge actually at the ICTR when, you're preparing a case, you interview witnesses, and by the time you're ready to call them to appear before the tribunal, some of them have died, some of them are very sick, some of them have had issues with their mental health. So it's extremely important that we tell this story now, and I think it's the right moment. And especially for the younger generations, what else can we give them as a legacy to ensure that what happened here is not repeated? I think that's really important. And visuals sometimes tell a story that words cannot.
Thank you so much, Florida. Philippe, how has directing this documentary impacted you personally, and what do you hope viewers will take away from your creative vision?
Thank you. I think personally, and even when I look back on my own journey, so what happened is after the genocide, because my family were refugees in Burundi, the killings that were mentioned earlier, especially by the Honorable Minister, in the 60s, in the 70s, my whole family had fled, so I was born a refugee in Burundi. And when we moved back to Rwanda in 1994, actually, right after the genocide against the Tutsi had been ended, I grew up here as a young person, just experiencing Rwanda in the sort of the rebuilding phase, but you're young and you don't quite have a grasp of what's going on, or at least the extent of, or the immensity of the moment that is happening. So fast forward, I get the opportunity to go study abroad, and as soon as I left, there was something in my head that said, well, you might be gone, but at some point you'll have to come back and rediscover your own country, rediscover your own continent. And that was a big drive for me. So I knew that as much as I was going abroad to sort of gain knowledge, being educated and whatnot, at the end of the day, I knew that I would return. And returning meant relearning now as an adult, understanding really the history of your country. And so in 2010, when we started Illum Creative Studio, what happened was, it was a result of a disconnect between what we were experiencing sort of day to day or on the weekend versus to what, when you Googled Rwanda, what you got. And we often call it the 2Gs, is the genocide against the Tutsi, or the guerrillas, because at the time, I think the government was starting to now promote the guerrillas, right, as a tourism product. So with that in mind, we set out to really change. Our mission was to really change what you Google, the results you get when you Google Rwanda. And to connect it back now to having an opportunity as a director, and to understand my role. I'm a translator. I'm a person who's really ingesting a lot of information. Like Florida said, it's these moments that we go through and we're experiencing as we're documenting these things. It's really sort of absorb as much as possible, to download as much as possible in what is in Florida's head. And I'm sure most of you know her. If you sit down with Florida, she will have a gazillion anecdotes within a very short time span. So really pulling out as much as possible out of that, and then now trying to translate it into a coherent story. And that's where it helps to have a cinematographer like Chris, because he's basically my eyes to what I'm trying to communicate. Again, just to highlight the importance of collaboration and partnerships, and really, you know, if I look just for this snippet and the amount of hours it took and the people involved, it's an all-Rwandan team. There's quite a big number of women. I would say maybe 4 out of 5 in terms of, no, 2 to 3 out of 5 is having women on the team as camera operators, as producers, as people who really think and drive that story. So, yeah, as a director, that's my role. I will try as best as possible to ingest as much information as possible, then work with Chris to now bring it to life. And it helps to have great experts like the ones we have here on the panel, and even for you guys here in the room, involve as much as possible the storytellers of the country, of Rwanda, because the nuances, the small things that we understand are quite impactful. I remember even a short story is one of the survivors from the Bisesero killings. What happened is we were visiting some of the sites, and he showed us where, I think I'm going to rely on Florida to remind me his name, but he showed us where his dad's head was hung on an electrical pole. And to see part of the pole still there, it's something that it doesn't matter. It's been 30 years and we're hearing these stories, and it still shakes you. And as we were walking back to the car, this is the part I was not ready for, is someone comes and shakes his hands. And then we get into the car, and he tells me in Kinyarwanda that the person that just shook my hand is the son of the person who removed the head from the pole because he was tired of looking at that head. I don't know what else to say. Yes, and then he threw that in a latrine. So these are stories that are hard to comprehend, let alone when they're written. And our role will be really to bring that to life in a documentary, in a film, like I said, on all these platforms, so it's available for as wide of an audience as possible, especially the youth, because they have to understand that these things happened. These things were real. Real people were involved. You might have been young or you were not born when it happened, but these are real stories, and films and documentaries are the best way to do that.
Wow. Thank you so much, Philippe. I just remember that moment when we were shaking the hand of the gentleman who threw the head of the father of the man we were with. And it just really shows us how important these stories need to be told so that everybody can understand what our country went through and what it should not go through again. Chris, so what are some of the artistic challenges you faced in depicting such a complex and emotional topic, and how did you overcome some of them? You're working with lawyers, that's for one.
Thank you, Benita. I would say, to an extent, I'm human. As much as I love the craft that I do, to an extent, I'm human. And then going back and revisiting these moments, I think I was telling Philippe, I'm like, I'm having to take some breaks. And eventually, Benita came to my office, and I told her I'm not going to look at this anymore. Give me a day or two, and then we can revisit. But those are the challenges that happens. But these stories need to be told. They have to be showcased. Again, going back, I got a scholarship from people I didn't know. I studied something that now I recognize is super important. And just to address the elephant in the room, maybe not the elephant in the room, but there's gonna be needed support for these stories to be told. The expertise, I can testify for the expertise. I'm willing to teach as many other Rwandans, youth, to do the same and tell these stories, but all collectively, it's super important. If there's any place I feel like in the world, this could be selective, but if there's any place that screams impact, I feel Rwanda ranks top. I don't know if you live here or you're visiting, you can drive around the city and you can see how beautiful and vibrant this city is, and the country itself. So with support to that, we need to take back and tell these stories, one, to fight the deniers, and two, to really educate the youth. I am sort of the bridge of the generation, but I would love for my kids and their kids to also get to know where they actually come from and to know this beauty, how to protect it, how to live with it, how to continue to honor it. And just my last point is I'm really, really, once again, grateful to you, Dr. Charles in Florida, for coming front and saying we're willing to tell these stories. And I've sat with Florida in our office so many times, and she always has, many other stories, and I'm always thinking, okay, maybe we need to write that down, we need to write that down. And she sparked a light in my head where it's like, we're telling stories of the prosecutors right now. There needs to come a time where we're going to be telling the stories of the medics as well, and what they were dealing with, and then everybody else. But there's just a vast majority of stories that need to be told, and we all collectively can put together, whether it's by expertise, finance, whatever it is, for us to come together and start to produce these stories. One thing I'm for sure, though, is that we have the expertise here in the country, and it's going to be told by the Rwandans who also understand exactly and feel, by the way, the stories. So that's the creative side of it.
Thank you so much, Chris. Dr. Charles, in your view, what are the key legal and ethical considerations that must be kept in mind when creating a documentary about such a sensitive and tragic event?
Well, like I said, the Rwanda Tribunal is or was the genocide tribunal. There is no other. We have to bear that in mind, that was really the focus of the work that we did here, and this is where we built the jurisprudence as far as that crime is concerned. The Genocide Convention of 1948 only existed on paper before Akeisu. And I don't think that there's enough being said about that in this country. There's some serious bragging rights that accompany that sort of accomplishment. Because you often hear Rwanda, they say the War Crimes Tribunal for Rwanda. There's nothing like the War Crimes Tribunal for Rwanda. In fact, I think we probably only have one conviction for war crimes. 95% of the convictions out of Rwanda Tribunal were for the crime of genocide or inchoate offenses concerning affiliated with the crime of genocide, conspiracy to commit genocide, direct and public incitement to commit genocide, complicity in genocide. It's not a war crimes court. It's a genocide court. And I think it's because the crime is so important and so rare in its occurrence, there's a reluctance in the international community to admit that this is where the jurisprudence was built. And that's why I say one of my own personal regrets was that the work wasn't actually being done here. But you know what? It is what it is. We're now on this trajectory to create this documentary. I am committed to it 100%. And we have a wonderful team that we're working with, a very passionate team, so passionate about this. And there is no reason why we can't get this done. So I'm very excited about this, and I'm ready to make the sacrifice and commitment to ensure that it's a reality.
Thank you. Thank you all so much for taking the time to watch this with us and following this panel discussion. And thank you to the fellow panelists. Let's head off to lunch.
Thank you so much, everybody on the panel. You have allowed the audience to deeply understand what the film was all about by also showing the reasons why it was needed and how it was actually put together. So this marks the end of the before noon session, and it is leading us to lunch break. Our lunch break was supposed to last for 50 minutes, and we'll be back at 3 p.m., and that means that we are about 26 minutes late, and I think we can recuperate it by making sure that we spend very few minutes during our lunch. If you buy the idea, again, we can be back by 3:15 latest. The protocol team will guide us where lunch is being taken from. It is outside in the tent. Enjoy your lunch. See you all back at 3:15.
Jikari. Ndumva waje kare kabisa. Oya. Une vision réelle devenue irréelle, la télé a montré des images éloignées sur des faits insensés, trop vrai pour être vrai.
La mort des innocents, lâchement sacrifié, sauvagement exterminé, stratégie préparée, génocide occulté sur fond d'impunité.
Kwibuka génocide yakorewe abatutsi, turwanye ingengabitekerezo ya génocide, dushyigikire ibi byiza twagezeho. Turibuka génocide yakorewe abatutsi, turwanye ingengabitekerezo ya génocide, dushyigikire ibi byiza twagezeho.
La terre qui tournait à l'envers, le monde qui marchait de travers, jusqu'à la descente aux enfers, la mort au bout du désarroi, une plaie qui ne se referme pas, c'est le coup de poing du diable.
Kwibuka génocide yakorewe abatutsi, turwanye ingengabitekerezo ya génocide, dushyigikire ibi byiza twagezeho. Turibuka génocide yakorewe abatutsi, turwanye ingengabitekerezo ya génocide, dushyigikire ibi byiza twagezeho.
Hurler, identifier, juger, condamner, exprimer des regrets, revivre ce passé. Pour s'en éloigner, il faut tout recommencer. Yeah, yeah.
Munyarwanda fasha dusindagizanye, herekeza undinde kurira, kuko muri njye nawe niho hari icyizere cy'u Rwanda.
Kwibuka génocide yakorewe abatutsi, turwanye ingengabitekerezo ya génocide, dushyigikire ibi byiza twagezeho. Turibuka génocide yakorewe abatutsi, turwanye ingengabitekerezo ya génocide, dushyigikire ibi byiza twagezeho.
devenu irréel. La télé a montré des images éloignées sur des faits insensés, trop vrai pour être vrai.
La mort des innocents, lâchement sacrifié, sauvagement exterminé.
wanze kwira, twibuka ijoro ryanze gutana, ijosi ryibasiwe bitavugwa, igihugu cyuzuye imiborogo, ubwoko bwahindutse icyaha. si wanze kwira twibuka ijoro ryanze gutana ijosi ryibasiwe bitavugwa igihugu cyuzuye imiborogo ubwoko bwahindutse icyaha
twibuke byabi bitavutika umuntu arebwa n'ibireba nta murengezi abona n'umwe
I hope you enjoyed your lunch and welcome back to this afternoon session. We still have 2 more interesting sessions, panel discussions to have. The first one is going to be on justice and reconciliation 30 years after the genocide against the Tutsi, the role of religion during and post-genocide. The panel discussion is going to be moderated by Lydia Timer. Lydia Timer works for Certa Foundation, and she'll be joined by Bishop John Ruchahana, whom I anticipate that everyone in the room knows about. Ruchahana lived in Rwanda until 1959 when he went into exile because of the civil war. He became a lay evangelist at the age of 21. He did his primary studies in 3 schools, Butete, Kinoni, and Gitare in Bukamba district. He completed his secondary studies in Nyamira Mihigo College at Gisenyi and in Goma in the Democratic Republic of Congo. Ruchahana served as the president of Rwanda's National Unity and Reconciliation Commission. Ruchahana has taken a stand against the position on homosexuality of the Episcopal Church of America, who welcomed the ordination of openly non-celibate homosexual priests as unbiblical. Ruchahana was a leader in the Anglican mission in the Americas, which was supported by both the Episcopal Church of Rwanda and the Episcopal Church of Southeast Asia. After being consecrated, Ruchahana elevated the status of the diocese, both spiritually and physically. He has improved the infrastructure by building new schools and renovating old ones. Shira Hospital has been reopened and a new cathedral has been built under his leadership. Ruchahana works with various boards in Rwanda and internationally. Kindly welcome him to the stage. The second speaker is Moses Ndahiro. Moses Ndahiro is the chairperson of Rwanda Leaders Fellowship. Ndahiro served as Hope International's Director of Spiritual Integration since 2023. Before joining Hope International, Moses served as the country director for World Relief. And prior to that, he had served the church in Rwanda through the Peace Plan and occupied several positions, including church health and training coordinator. His background is in information technology, where he majored in internet systems. He also holds a master's in international development from William Carey International University. He has a passion for addressing roots of human problems and unlocking people's potential to fulfill their God-given purposes. Moses is married to Benita with 4 great children, Lucas, Leanne, Leah, and Lewis. And in his free time, Moses enjoys playing chess with his friends. A round of applause for Mr. Moses. The rest, I hand it over to Lydia for the moderation, and I hope that you are going to remain engaged as it has been the case in the morning. Over to you, Timer.
Thank you, Kalinda. Good afternoon, everyone. After a long morning of amazing and engaging discussions, and after a refreshing lunch, I hope that we are back here re-energized, ready to grasp. They did not mention the other panelist? Oh, Kalinda, how do you forget about Mr. Charles? Mr. Charles, please welcome. A round of applause for Mr. Charles. Thank you so much. Yeah, so I hope that we're back here all re-energized and ready to take in, to grasp the wisdom, the knowledge, and understanding from our distinguished panelists. Kindly join me and help me to give us a round of applause to our distinguished panelists this afternoon. They are going to be discussing about the role of religion during and post-genocide, justice and reconciliation 30 years after the genocide against the Tutsi. And so please stay tuned and let us learn from these distinguished men from the religion, full of wisdom, knowledge, and understanding. As we reflect on the 30 years since the genocide against the Tutsi, religion has played a multifaceted role both during and after this tragic period. We saw religious personnel who saved and those who participated in the crimes themselves. Can please each one of you share your perspective on how religious institutions and leaders influenced the events of the genocide and the dichotomy of how those religious powers or the religious individuals can lead both to further destruction or in the construction of a society. We will begin with Honorable Bishop John. Thank you.
Good afternoon. I think the fact remains that religious leaders or religions or the religious personnel or members of the religions can again, it's possible that they can again get involved into destruction. Humanly, the tendency for the human beings can either do wrong or right. As you know, there were some religious leaders who worked very hard and stopped, saved, but there are those who participated. I think what needs to be done today, not only by religious leaders, but by the community, is to put measures that recover religious leaders into the newness of ideology on how they can serve better and live for what they are called to be. So you can't rule out the possibility that it can happen again, but there must be measures to prevent it from happening again. So religious leaders today in Rwanda are not the same as they were during the genocide. There has been some transformation, and there is the newness of ideology, the newness of commitment, and the regret, because the 30 years in Rwanda has really appealed not only to the consciences of the communities in Rwanda, but also to the religious leaders. Religious leaders in Rwanda today have regretted their failure, not only during the genocide, even before the genocide. Actually, I wish you mentioned even before the genocide, because the genocide does not strike like thunder. It is planned, it is tried, it goes undercover and executed. So by that time, the religious leaders were in Rwanda. And the religion is not only Christianity or Islam. Even before Christianity and Islam came to us, we were religious. As Professor Mbiti puts it, that Africans are notoriously religious. We need to recover who we are as religious people and then be able to do the best of ourselves. So we have, therefore, to learn from our past. Then that past should renew us into the newness of life and a new commitment to being better and be able to ameliorate and work for our destiny. That's all I can say about that.
Thank you, Bishop. I like your mentioning of the new commitment and the newness. Now let's listen from Moses. Thank you.
Yeah, I just want to start by acknowledging the opportunity that Certa and RBA have extended to us to be part of this panel and share some thoughts. So thank you so much to the leadership of Certa for making this possible for all of us to enjoy. The question you've posed is quite complex, looking at the role that we all play, because we are all religious in one way or another, and we all bring that into whatever we do. And so, as you rightly put it, there are some that did, really some great acts during the genocide, and there are other leaders that did the horrific and the traumatic events that we are all aware of. However, as we all know that in every sector, there are, bad leaders and good leaders. It happens in the church, in the religious sector. It happens in the government. We had some bad and some good leaders. It happens even in the, justice sector, and it happens all the time that you have some great leaders and some, bad leaders across the different environment. And we all are looking forward to the great leaders. So just to summarize your question on the influence part, I think the church and the religious community did what they could, and hence the results of what we did of some good leaders. However, they also failed because there were some leaders, some church sites, church buildings that were very involved in the genocide against the Tutsi in 1994. And moving forward, as Bishop was mentioning, I think it is important to realize that there is work that is being done. Like every other sector is trying to, take stock of what went wrong and then fetch out of that to build the next steps. Yeah.
Thank you, Moses. Charles?
There were many more Tutsis killed inside churches than anywhere else during the genocide of Tutsi. It's a fact that many people in Rwanda don't like to admit, but I'm a prosecutor, and I obtained the very first genocide conviction against a clergyman in the world. A man called Pastor Ntakitirumana, who I prosecuted alongside his son. He was a medical doctor at the Mugunero complex. So both father and son had sworn in their respective professions to save human beings. And they did nothing other than just take lives. There were many more Tutsis killed inside churches than anywhere else in Rwanda. And I dare anyone contradict me. And the reason for that is obvious. Once there is no separation between politics and religion, you end up in exactly the same way this country ended up in 1994. It's as simple as that. There's no wishing it away. There's no nice way to sugarcoat it. There's no nice way to... It is what it is. The church and politics were hand in glove. It is quite as simple as that. And the only way to prevent a repetition is for politicians to stand on one side and the clergy to stand on the other. And I say this in my country all the time. Once the church starts to get involved in the politics of the land, we're going to end up exactly the same way Rwanda ended up. And they say, what do you mean by that? And I say to them, well, do you know that there were many more people killed inside churches in Rwanda than anywhere else? More than stadiums, more than offices, more than roadblocks. The church had taken sides in the politics of the land. If we think that's a good thing, well. If we think it's a bad thing, well. But you know what? We have to call it what it is to be able to avoid its reoccurrence. If we sugarcoat it and we dance around it, then we risk a reoccurrence. And that's really my view on this. Because you see, I was only 31, 32 years old when I joined the ICTR. my faith as a Catholic was tested by this. Not only was I traumatized by having to prosecute a clergyman for atrocities that took place within churches, one after the other, as we're doing it in Mugonero, we're doing it in Bugesera, we're doing it in Mubuga Church, and it's one church after another church, and Home St. Jean, and Intarama Church. No one can preach to me about what happened in this country vis-a-vis churches and politics. I lived it, I prosecuted. And it tested my faith, more so when we cross-reference what was going on in churches to the reaction of the Muslims at the same time. So the recurring theme in our trials was about what was taking place in Yamirambo right here, just down the road here. This Yamirambo here, the stronghold of the Muslim faith. And stories after stories and testimonies after testimonies as to how the Muslim faith dug holes in the foundations of their mosques to hide their neighbors, whether they were Tutsi or Hutu, mostly Tutsis, and covered them up with praying mats when the attackers were coming, and gave them food and water. And there is not one documented genocidal case of an attack. And I repeat, not one. And I will know, because I lived and I breathed this job for 12 and a half years. Not one genocidal attack recorded inside a mosque. Anyone can challenge me on it. So after a while, as a private citizen, I stood back and I started to ask myself certain questions. Because in Nigeria, we have 50-50 Muslim and Christian. And I said to my brethren, I said, I did this job in Rwanda. This was the reaction of the two religions. But why? How so? How could the two religions have been so detrimentally different, their reactions? Some said, it's politics maybe. Some said, Islam is practiced as a way of life. So I said, is Christianity not practiced as a way of life? Well, it's supposed to be practiced as a way of life. Yes, that's the ideal. Again, they were dancing around the issue. But it seems as if the Muslims actually took it a little bit more seriously. Be your brother's keeper. So I said, so that is the reaction. So that's the explanation to why the reaction of the two religions were so different. So maybe we don't know. We're just saying. And those are the kind of discussions we need to be having here. Honestly. In the same country, how could two religions have reacted to a set of events so detrimentally differently? How? Why? I don't know. I don't have the answers, Lydia. I don't have the answers. I wish I did.
Thank you, Charles. Thank you so much. So you have emphasized on the role of institutions not actually separating their principles or what they stand for. The politicians ought to have stood their position, and the clergymen ought to have stood their position. Unfortunately, that was not the case here in Rwanda. So having said that, Bishop John, let's now talk about restorative justice. What has been the role of religious organizations and entities in ensuring restorative justice and reconciliation, given the role of some church leaders played in perpetuating or even perpetrating violence during the genocide against the Tutsi? what has been the role of religious organizations in restorative justice in Rwanda?
Thank you very much. I think the role of the religious leaders or religious organizations and institutions in the restorative justice and reconciliation, for that matter, has been actually one of the major one is the appeal to conscience. First and foremost, as the panelists are saying about the failure of religion and the failure of institutions in Rwanda during the genocide, the religious leaders in Rwanda after the genocide, post the genocide, did a great role in the appeal to conscience. Their own consciences as religious leaders and the consciences of the members of the church, of their organizations, so that they can see the magnitude of the failure, to begin with, the magnitude of the failure. First and foremost, churches were meant to advocate for the well-being of the society, the members of their society, members of their churches. Appeal to conscience in the reality, or in a sense that they needed to see how grievous was the failure not to defend or not engaging the power which was propagating for the genocide. First and foremost, the divisive policies that were introduced in this country were there when religious leaders were seeing it. Having been prophetic in calling, they should have prophesied, they should have spoken against the disaster which was going to happen to this country. So when we talk about the appeal to conscience, we are appealing to the conscience, or we appealed to the conscience of religious leaders and the communities first and foremost, and then to the community. Because the horrors did not only affect the victims of the genocide done against the Tutsis, but also it was done against humanity. It depleted the morals of the society. It depleted the dignity of not only of the human beings who were affected, but also of us as Rwandese, as a people. So the appeal to conscience was one of the issues that we have done as religious leaders. Two, we have engaged the first restorative measure done by a Christian organization known as Prison Fellowship, in collaboration with the Prison Fellowship International, was done in Rwanda and was also implemented in all ministries all over the world. So Prison Fellowship Rwanda was the first to engage that, and the results, the teachings that was developed was actually done with the Rwanda prison ministries at that time, before it became RCS. We were together learning how to approach the community and the prisoners and the survivors on how we can restore the sanity in a community. Then we also had the conferences with religious leaders, conferences with other institutions, so that we can engage the reconciliation and we can appeal and reestablish justice and affect impunity by knowledge and by appealing to the consciences, learning from the past. We also were involved into the beginning of Gacaca. Some people don't know this, but at the very beginning of Gacaca, we were invited to go and speak to religious leaders and the leaders in the communities where Gacaca was going to be introduced first in a few given communities. So we got involved into that because this issue of appealing to conscience was very, very important. having begun, of course, with ourselves. And we also got involved very much into the appealing to some of our international members of the religious communities to understand the efforts and the progress, comprehend the efforts and the difficulties that the Rwandan community and the Rwandan systems were engaging to recover the nation. So basically, there were lots of efforts done by religious leaders, religious institutions into the recovery of the country and the restoration of justice, especially the restorative justice. Because in Rwanda, we couldn't do one with one side and leave the other. We got involved into both because we needed to recover both. Many people don't know that survivors of the genocide who were actually targeted needed recovery, and those who perpetrated agony upon them need also to recover the other sense, because they were suffering from a huge guilty conscience. And both being Rwandans, they needed to get a meeting place somewhere, and we needed to get involved into that. Because you cannot make a nation with one side of the coin. We need to get them both together. And the religious leaders therefore got involved. I can share further facts and information needed if there is need or time. But religious leaders got involved very much into that process. Thank you.
Thank you, Bishop John. You have highlighted on the important programs and initiatives put in place by religious leaders and institutions post the genocide in as far as ensuring restorative justice. But before we are out of that topic or that area, let me go back to Mr. Moses. Many leaders in the Habyarimana government who played roles in the 1994 genocide against the Tutsi were also influential figures in the church, often being significant contributors. How do you see the intersection of leadership and religion today? What specific steps are being taken to prevent the intertwining of religious influence and political power from fostering harmful ideologies and actions in the future? Drawing from the amazing programs and initiatives that are in place, which Bishop John just mentioned.
As mentioned. Thank you so much, Lydia. Before I respond, I just want to reflect on the question that Dr. Charles has highlighted, and I don't just want to go over it without shedding some questions or comments. One is, as I was sharing, which I really appreciate, is I asked myself, what made the church a safe space for people to come there? Why did they come? I don't know. But I'm sure there was a reason as to why. And I'm saying this because I live with a dad who lived in Kwibuka, survived at the same church, St. John. I was known there during the genocide in 1994, but I was in Kwibuka in November 1994. And I was there to understand why. Why did they find the church? Who did the killings? I believe, and I stand to be corrected from those that have done extensive research, if really the massacres that happened in the church were done by church leaders and the nuns, or there were other people that came and found people at this place that was thought to be a safe space, and people were found vulnerable and, killed the way that happened. So again, I stand to be informed and educated, but from what I've heard, it seemed to be a safe space, And did the other religions participate? I don't know. I need to do thorough research. I'm glad Certa is here. That would be a good, exercise to conduct and inform all of us. What was the role of the religious sectors, that we have in this nation, so that this comes to be clear, even us that are involved in the religious sector, that we can continue to tell the truth as it is. So I just wanted to highlight that. Secondly, to your question on the intersection of leadership and religion. I think it is an evolving landscape, and it remains to be complex again. But one thing, again, that I would want to highlight is, as we all assume roles of leadership, we come with a certain level of religion and faith. And that informs how our worldviews are framed and how we define truth. You may have a religion or may not have, but still you have a relationship with the divine or the superpower in one or another. And that, in one way or another, informs certain decisions that you make. And I think as we get into the leadership roles, it's upon us, and I'm so glad that when God made all of us, He gave us the capacity to make choices, you know, which gives us the ability to really decide on what is right when done collectively with a heart that is discerning to really know the truth. So with that said, I think there is space for us as religious leaders to be part, you know. However, some of the steps that the government or leadership has taken is to create space for education and awareness that Bishop John was referring to. There's been a huge realization, as I was sharing, learning from the past, that there was lots of education needed, that some of these leaders assumed roles and they were not fully equipped for the assignments that they had. All true values, they never had opportunity really to understand what is this faith that I'm getting part of. And you see that in our history, how there were mass conversions that happened just because someone had made a decision. And so that also informs how we, you know, used those spaces of faith. So education and awareness is one of a key step that has happened, and you've heard in the past years where even the government has encouraged church leaders, go back to school, get your degrees, to ensure that the faith leaders, really, when they stand, when they lead, they make decisions, they're making decisions from an informed position. But also, our constitution is very clear that Rwanda is a secular state, and that has also, you know, been a part of the learnings that we've made in the past, and realizing that we also have, you know, freedom of religion, you know, that is also available, and those should learn how do we play politics together, because as a state, there is a faith community that, because when I'm a government leader or whoever, we are serving the same people. On Sunday, you'll call them a Christian. Mm-hmm. The government leader will call them a citizen. A doctor calls them patients. Teacher calls them students. But at the end of the day, it is this same citizen that we are serving. And I think there is need for collaboration for all these sectors to really realize that at the end of the day, all we want is to see lasting change and true transformation happening in the nation.
Mm. Yeah. Thank you so much, Moses. Bishop. Okay. Thank you. Let's go back to prosecution of the clergymen. Charles, your extensive publications and expertise in international criminal law include insights into the challenges of international investigations and prosecutions. In this light, what would you say were the main challenges found in prosecuting and investigating religious personnel, often sheltered by powerful institutions? In your experience, what are the primary obstacles in addressing these challenges? And do you believe there has been sufficient progress in overcoming them?
Let me start off by, before I come to your question, or to answer your question, start off by answering what Moses, the question he posed. You see, the reason why this whole nonsense of a double genocide does not stand in my mind, or in anybody's mind, anybody's right-thinking mind, is because genocide by its very nature is planned. There was no spontaneous attack on Tutsis gathered inside churches. None. There was no mistaken Hutu civilian gathered inside the church. None. Political leaders met with local leaders in the aftermath of the downing of the president's plane, because churches were preconceived safe locations in prior conflicts. They knew that people were going to go to those locations for safety. And the leadership of the clergy were complicit in encouraging those civilians to gather at those churches. Leave your homes, come to the churches, lock, stock, and barrel. They actively encouraged them to come there. Those that were at home, what are you still doing at home? You're going to be safe here. Then they encouraged the attackers to come when they were satisfied that those churches were full up. Because those attackers that were guarding those churches were telling those people in there, tomorrow is your turn, we're going to kill you. That's how come Philip Gorovich, the American journalist, got hold of a letter which later became the title of his book. The letter was written to Pastor Ntakiti Rumana. We wish to inform you that tomorrow we will be killed with our families. I got that letter in my hand. Philip Gorovich gave it to me in New York. The congregation had written to this man in the hours before the attack at Mugunero, saying, Pastor, save us. These gendarmes have told us that we are going to be attacked tomorrow. The letters was delivered to him, and he did nothing. That's a crime in international law. That's complicity. I don't need you to be a machete-wielding pastor to be guilty of genocide. All I need you to do is to stand aside and do nothing. That's what the law says. It's a direct form, it's an indirect form of participation, but it makes you guilty of genocide. So that's the way it happened. We never said that clergymen were wielding machetes and shooting rifles. No, they never did that. They didn't have to. But the role they played was sufficient enough to ensure that the outcome was what it was expected to be. They were complicit in all the locations. Maybe one or two examples, Father Seromba here or there. Even, in fact, it got so bad that if we had a witness telling us that they saw a priest holding a gun, we look at him with suspicion, because we knew that wasn't the case. We knew they were not active assailants in that sense. What they did was they created the enabling environment to facilitate. And then to answer your question, and I have answered it by implication, because of that less active mode of participation, what the cases against them were that they created the enabling environment and actively encouraged. So they aided and abetted the crime of genocide. There are different forms of legal participation: participating, committing, aiding and abetting, etc., etc. You would find that in the cases of the clergy, what resonated throughout Rwanda was that a lot of those clergymen aided and abetted, either by transporting attackers there or by standing aside and by way of omission and doing nothing and letting the attackers conduct or kill Tutsis in those locations. But the way you would know that there was an active plan on the part of the state was that there was no Hutu that was in that church by accident. How is that possible now? You evacuate the whole of Mubuga sector and you say, all go and gather in Mubuga Catholic Church. And everybody that happens to be in the church happens to be Tutsi. No Hutu strayed in there by mistake. Because they say, no, we're not, you don't need to seek refuge here. You are not the one that needs protection. And that is what makes it a genocide. Because remember that to be a genocide, it is not the act of killing that is being punished. That's not what makes it a genocide. It is the targeting of members of a group identified to be such. That is what makes it a genocide. It's not whether or not 10 million people were killed. The killing of one man can constitute a genocide, provided the perpetrator did it with the special intent to destroy in whole or in part that man as a member of a specific group, having identified him as belonging to that group. That is what makes a genocide so complex to prosecute. Does that answer your question?
Yes.
Have I confused you even more?
No. Actually, I have a foreign question to that, and I'm going to begin with you. Thank you so much, Charles, on your expertise. Now, you have mentioned about the bigger number of Tutsis being killed inside the churches. And you have mentioned about the complicity of the religious institutions and religious leaders and even the religious people, the Rwandans. Now, let's talk about now the punishment of those religious leaders. Cases such as Nakiritimana drew criticism for receiving lenient sentences compared to the severity of the crimes committed, reflecting a broader undervaluation of religious roles in such atrocities. Would you kindly, Charles, help us to respond to the criticism that the sentencing in cases like Nakiritimana reflects a broader societal undervaluation of the roles of religious leaders in perpetrating genocide against the Tutsi in Rwanda?
Thank you. Now, if you heard me speak in the last 5 minutes, I very, very clearly outlined what I described as an indirect role for all these religious persons. And I said, maybe with the exception of one or two, there were no religious people who were wielding machetes. Okay, so what that portends is this. Even though we're prosecuting the crime of genocide, there are many varying modes of participation in that crime. Some are more direct, some are more indirect. Like I said, a lot of the evidence concerning the clergymen was of an indirect nature, providing an enabling environment, providing weapons, of transporting attackers there, or allowing their churches to be used as a gathering. That's a very indirect mode of participation. So when you hear Ntakitirumana was convicted of genocide, yes, that is true. But the sentencing of Ntakitirumana must take into account the role he played as part of the commission of that attack. And his sentence, or the sentence of whoever is convicted, I'm just using Ntakitirumana as an example, must be reflective of that role. Let me give you an example. Mika Moimana, he wasn't a priest, he was a conseiller. But Mika, the evidence was that he was raping women personally. He was encouraging his men to rape women. He was killing people. He was involved in very direct. If Mika is guilty of a genocide, and on one hand, keep that on your left hand, and Pastor Ntakitirumana too is guilty of a genocide, but for a more passive, indirect involvement, the sentencing of Mika and Ntakitirumana will reflect that role. Okay? We cannot expect the man who just made his Pajero available to carry attackers or locked the door of the church to earn the same punishment as the man who was raping women, disemboweling women, and being involved in a more direct participation. So what you find in the Intaki Romana case was that the trial chamber tried to distinguish between his mode of participation. That's the legal term. They say the mode of participation. So the evidence suggests that his mode of participation was XYZ. So in sentencing, they would try and distinguish between that mode of participation. But why Intaki Romana got such a lenient sentence was on account of his age. And I had problems with that, personally. Because you cannot be too old. You're not too old to commit a crime, but you're too old to serve the punishment. And the trial chamber said, oh, on account of his age, I think when we started his trial, he was 73. And then by the time his sentencing, maybe he was 75 or something. He wasn't 80 years old yet. They said, oh, he was old, he was suffering from prostrate. Who doesn't suffer from prostrate? So what's the big deal about that? He's old. I'm like, well, he wasn't too old when he committed these crimes 10 years ago. What's all this nonsense about? Anyway, but that's international justice for you. The judges are trying to distinguish between various forms of culpability and various personal circumstances, you know, age, remorse, and all that. We all know why Kambanda. Do you guys know why Kambanda got life? Even though he pleaded guilty? He's not a clergyman. Kambanda was given the opportunity, and this is I was talking earlier about the difference between the adversarial system of justice and the inquisitorial system. And what Florida was saying earlier about the, not a conflict, but the merger of legal systems and our cultures. This is what happened in Kambanda. Kambanda pleaded guilty. Didn't come into any deal with the office of the prosecutor. He pleaded guilty as charged to everything, and even volunteered to collaborate with us in other cases, give evidence. His lawyer was from Cameroon, from common law side of Cameroon, a man called Oliver Inglis. The presiding judge in the trial was a man from Senegal, the late Leyti Kama. During the sentencing hearing, Leyti Kama turned to Kambanda's lawyer and says, will your client like to say anything to the court? Oliver Inglis turned around to Kambanda. They looked at each other. And the lawyer stood up and told the judge, no, my client has nothing to say. Ah. You see, if you say that to a common law judge, that's understandable. Because you see, lawyers speak on behalf of their clients. If you say that to a civil law judge, it has a different meaning. It means he's showing no remorse. So, Oliver Inglis should have known the difference because he's from a bicameral system in Cameroon. So when a judge says, does your man want to say something to the court? What Kama expected Kambanda to do was to make a plea to Rwandans in remorse. I'm so sorry for this happened. You know how you make a plea. But he felt that his lawyer had already made the plea. So he said, I have nothing to say. He got life. And then on appeal, he appealed and said he received bad legal representation. I don't know, the jury is out. Was he properly represented or not? That's for another day. But this just draws your attention to the challenges we had in the way, the reaction of the different legal cultures to things that were basic. Just no fault of anyone, just because lawyers and judges belong to different cultures. It's unique to international law.
Wow, that's interesting. Thank you so much. Now we understand the interplay of different legal systems and the role they played in actually sentencing and prosecuting the genocide, the crimes against genocide. Yeah. Now, thank you so much, Charles. Bishop John, in your opinion, how has the role of religious leaders evolved in Rwanda's post-genocide society, particularly in the context of promoting justice and reconciliation? In particular, can you discuss the importance of interfaith dialogue in fostering reconciliation and social cohesion in Rwanda?
Thank you. Before I answer that, I wanted to just add on to what Charles said about people getting into churches, being mobbed into churches in bigger numbers. and having only the Tutsis in the churches without Hutus, because there was no reason for any Hutu to go into churches, because they were not being hunted for. But the Tutsis were mobbed into churches because they used it actually as a trick. In 1959, for those of you who are young, in 1959, when they burnt the homes of the Tutsis, and those members of the inner political party, which was the national political party at that time, they ran into churches for safety, and they were indeed saved. So they used that as a trick to mob all the Tutsis who are being hunted, to put them into churches so that they can find them there and kill them in big numbers. So that was the trick. So to answer your question on the role of the church in restorative justice and the interfaith, for the first time in the history of this country, those of you who know the history of the country and the religious settings in Rwanda or in other African countries and the colonies, the Catholic Church was a state church. And being a state church, all the policies were made and at the knowledge of the church. And the other churches at that time really desired and they wished to be favored like the Catholic Church was favored. So there was no interfaith at that time. For the first time after the genocide, the Rwandan churches began to have some platforms of meetings and where they can be able to discuss their recovery, discuss their failures and losses, and therefore, through those platforms, they started also thinking on how they can engage some reconciliation and talk about the required justice in the country. Because not only church leaders, but even members of the community knew how much impunity reigned in this country. So basically the first institutions to be established as far as the interfaith platforms were done after the genocide. I wish they could do better even today, because the challenge that the religious organizations and the religious institutions have today is that they haven't been united enough to be able to decide and plan together how they can heal the wounds of the society, how they can plan for a better service and their own recovery of confidence in our society. Because it's a journey they have to do together as a team, serving the same God. No matter how many churches you may have in this country, they are serving one God, single God. They are serving the same community, and they are leading people into a destiny together. So in order to do that, therefore, they need to possibly do better, developing a sense of unity and developing a sense of ameliorating their performance in the society, in order to be much deliberately much better in accountability to the society, and transparency to the society and the members of their churches, so that they can regain the confidence of the people and the confidence of the society. So basically, I think there is a challenge. I wish they could do better, although they have started on it after the genocide. They are trying to do well. They're trying to engage restorative justice. They are not only restorative justice, but also be able to train people to have the decency, the human decency, which we really lost. Because we did not only lose 1 million people in 100 days, but we also the human decency. It's And it's a shame that religious leaders who are meant to be prophetic, who are meant to be there for their people, lost it. So basically, the interfaith is meant not only to have justice for the people, or restorative justice to the people, but even to themselves. And the charity begins at home. So really, that's what I can say on that.
Thank you, Bishop. I can see Karinda there, so that's a sign that we have to close off this session. Please allow me to just close off with one question towards Moses on how can we balance the autonomy of religious institutions with the need for accountability and oversight. How do we balance the autonomy of religious institutions, and yet we have to hold them accountable where they have not provided the oversight they ought to provide?
Thank you so much, Lydia, and glad we have lawyers in here. In case I miss something, but this is what I would share. One is everyone in this nation is accountable, irrespective of your religion. So I think that has been very clear, that your acts, if they are against the law, and we hear this over and over, even when our leaders swear being sworn in, that they are going to be accountable for misusing their power, misusing their position. So I think that has been made very clear, that everyone is very accountable. However, everyone has a role to play, as I've said, that the state has a role to play, and the religious community has a role to play. And it is upon us as leaders to discern the future together and say, this is my role, this is what I can do. Like moving forward, we've seen tremendous input after the 1994 genocide against the Tutsi, how the church has helped in the trauma, healing, unity, and reconciliation efforts. So that is one role that continues to happen, and the church is very ready, and I think positioned well to help in that area. And many other areas, including social and economic development for the victims of this atrocity that we all had. So all to say in brief that everyone is accountable, the law and the provisions provided in there are very clear, and hope we can comply.
Yeah. Thank you, Moses. Ladies and gentlemen, this panel has really done a great job in teaching us about the past. So as we learn from the past, as we embrace the new commitment, which Bishop John has mentioned about, as we impart godly values in our undertakings or our doings that has been mentioned by Moses, let all those new perspectives and godly values underpin our daily doings so that we lead to a more just and equitable Rwandan society. Kindly allow me to give a final round of applause to our panel discussants, and thank you very much for your attention.
Thank you.
Thanks for the great work to our panelists and moderator. It was really insightful, but time is not on our side. That's why you saw me standing here, just as a warning that time is running. We are coming to the last panel of our today's conference. The roadmap for combating impunity and ensuring justice for genocide survivors is our last panel discussion. I have the pleasure to introduce Mr. Michael Butera, who is the Chief Technical Advisor at the Ministry of Justice in Rwanda and a Senior Fellow at the Center for Law and Innovation at the Certa Foundation, where he most recently served as an Associate Director. He has worked with various prestigious institutions, including the Beckman Klein Center and the Radcliffe Institute, both at Harvard University. Additionally, Michael has worked with the European Center for Constitutional and Human Rights in Germany and the Chartered Institute of Arbitrators in Kenya. Michael holds a Master's of Laws from Harvard Law School in the United States and a Bachelor of Laws from Strathmore University in Kenya. He has published several articles, including Against Genocide Denial, A Universal Responsibility to Truth. Michael, welcome on the stage. You allow me to skip the introduction of the first panelist, Dr. Charity Wibabara, the head of International Cooperation at Ministry of Justice. I think I gave enough justice to our introduction before lunch, and the bio remains the same. And then allow me to introduce the second panelist, Mr. Janvier Bayingana. Bayingana is the Justice Commissioner for Kwibuka and an active member of the Rwanda Bar Association. He has worked in this field of law for more than 24 years. He represented the interests of survivors and worked for survivors at the community level for more than 2 decades. A round of applause for Bayingana. The third panelist is Siwainhore Jean Bosco. Siwainhore is a national prosecutor and the head of the Genocide Fugitive Tracking Unit at the National Public Prosecution Authority. He was appointed to this position of national prosecutor and head of GFTU in September 2011, and prior to that, he was a prosecutor at the intermediate level, and before the judicial reform of 2004, he had been a substitute procureur from 1999 until 2004, and a crime investigator from 97 to 99. Pertaining to education background, Siwainhore holds 2 master's degrees in law, one in global criminal law obtained from the University of Groningen in the Netherlands, another one in the public international law obtained from UERICA in Rwanda, and he also holds a bachelor's degree obtained from UNILAC. He holds a postgraduate diploma from the Institute of Legal Practice and Development, where he is also a part-time lecturer. Allow me to hand over to Mr. Michael to moderate this very meaningful panel discussion that is actually going to be the main takeaway as we conclude all the sessions for today's conference. Over to you, Michael.
Thank you, Kalinda. Good afternoon, everyone. Usually when you're running the last panel, you pose to have 3 risks. So one is that you have very low attendance, and second, the same attendance is very tired and fatigued, and third, the concentration level is very low. So some people are sleepy. I was trying to look around, and it doesn't look promising, you know. But we try to light it up, and you know, some of the people here, my colleague, Dr. Charity, and the rest have actually been the people I've been looking up to when I was growing up. So it's great to share the stage with you. I'm very, very humbled. So to just go straight to the point, I will try to make it very, very fast. We don't have so much time. And I will just go back to the very morning session when Maggie started moderating, and she was reciting cases of the former Nazi officials who are still being prosecuted. You know, actually, until recently in 2022, the 101-year-old Joseph was prosecuted. So prosecuted over crimes that was committed in 1946, around 7 years later. So and therefore we come to the panel, and this question goes around throughout the 3 panelists, which is that. You know, given is there an expiration date to prosecuting the crimes that were committed during the genocide against the Tutsi in 1994? And if that expiration date of prosecuting and actually chasing down the perpetrators is there, are these people, perpetrators, exempted from accountability? And so, in short, do we reach a point and say, you know, justice has been beyond served, we can't keep going? And then we should stop and say, you know, the rest are exempted. Because there have been sentiments in academia and everywhere which suggest that, you know, it's been 30 years and people have to move on their lives. And, you know, so just your reflection, what you think about impunity and accountability and those framings of the problem. Maybe over to you, Charity, and we'll go some line.
All right. Thank you, Michael. Is my voice clear? Yeah. All right. Okay. Thank you for that interesting question. One, you're wondering whether after 30 years after the genocide against the Tutsi, is there expiration for prosecution, for investigation of these for genocide? One, remember that international crimes, which are mainly three: genocide, war crimes, and crimes against humanity, they do not have an expiration date. We have a principle like imprescriptibility of international crimes. So once you, which is different from the ordinary crimes, murder and others, which have a date or like it depends on which kind. Is it a felony, a misdemeanor? Maybe after 10 years, after a certain kind of years, then it is over. But for these international crimes, once you're, you have committed international crimes, there is no expiration date. So coming to the point that you raised, that 30 years after the genocide against the Tutsi, or should we say there has been impunity? No, not really. And should we say we still need justice? Yes, we need it. Yes, or if I explain that from the statistics, we do agree that the Gacaca trials, which the Minister of Justice presented in the morning, they've been able to try 1,958 cases in a period of 10 years. That is justice served. Almost 2 million cases, because Gacaca started operating 18th June 2002 to 18th June 2012. So they were able to try close to 2 million cases. And then if you look at the national courts, which started operating, or which were revived in 1996, they tried over 10,000 genocide cases, and the ICTR 75 cases. If we go to third state prosecution, that is to mean trials that have happened in different countries, we have 30 prosecutions and trials. But still, with those numbers, they are significant numbers. We recognize the tremendous progress to fight impunity, to ensure accountability, but the challenge still remains. If I can ask my fellow panelists or even the audience, if we look at the statistics that are provided by the NPPA, they provide that as of to date, they've issued 1,149 indictments. And the reaction that we've gotten from countries, it is just 30 third state prosecutions and 30 extraditions, transfers, and deportations. Where are the others? So that is impunity for international crimes. For international crimes for the genocide against the Tutsi. So the challenge there for the victims, they are not interested in numbers. Whether you say 2 million cases by Gacaca, 30 prosecution in other states, or the national courts have tried 10,000 cases and above. For them, their interest, what lingers in their mind is what happened, the consequences they suffered. So even to them, one fugitive, one perpetrator that has not been arrested to face justice is a challenge for them. So that's why impunity should not be tolerated for these international crimes. And I will end with one question. We were just talking about the indictments, the 1,149 that were issued. When Gacaca was closing on 18th June, actually tomorrow is an anniversary for Gacaca because today is 17. So it handed to the NPPA 71,658 fugitive files. If I can ask a question, what is the current status? That means that if we have those files and we consider them fugitives or not fugitives, but there is a missing link, we still believe that there is impunity. We acknowledge the progress, but we also recognize that even one perpetrator, and now for our case, we don't even have one perpetrator, we have thousands of them. So we still need justice, and for these crimes, they do not expire. We need to pursue the perpetrators. Thank you.
Thank you very much. So there's no expiration date to this, and as you said, impunity is not measured vis-a-vis numbers and whatnot. It's most of the humans at stake and what happened and the victims. So maybe to May, do we see prosecution and justice served to the victims in terms of time frame? Does really time matter? Whether people should after 30 years people should relax or not relax in matter, but try to start reflect on something different than justice, or justice has to follow the suit until the end of the chain, which is perpetrators have to be brought down and victims have to be dignified in provision of that, access to that justice that they yearn.
Thank you, Michael. In the first place, I would take a kind of waiver of a disclaimer. I'm the only panelist that the AMC did not mention any academic or professional records. It was not by mistake. It's just merely because I'm trying to raise a little bit the voice of victims.
Nice.
And I'm standing here not as an academician, not a brilliant speaker, standing and raising the voice of victims. So for the victims, genocide survivors, victims, the concept of justice is an ideal. Mm-hmm. It's an ideal, does not reflect, is not proportional to the effects of justice. I mean effects of genocide. Why? Genocide survivors in the first place have not been interested. There was no need of justice for them because they was there as human being who deserved the right to life. Now, we are just discussing about collateral damages after the danger came in. So, in the first place, in the mindset, in the survivorship perspective, there was no need of being a subject to justice. That's point number one. Point number two, in the mindset of genocide survivors, there was no need, as Dr. Charity mentioned on the right said, there was no need of records, statistics, mandates, achievements, and any other corrective or individual celebrations when it comes about the justice. In the mind of genocide survivors, all they wanted, it's not having ICTR, successfully serving, number of the cases, having domestic justice, having international justice. So I just want to make clear as it is. Number three, just trying to say that the kind of justice of domestic or international justice that you are referring to, or referred to in the previous sessions, the morning session, the afternoon sessions, was a second or third category of the real justice that was deserved to. Why? The first alternative was seeing genocide perpetrators being arrested, prosecuted, and sentenced in Rwanda for various reasons that one may not outline. The second option was seeing perpetrators being held accountable before international justice system. The last one was seeing under universal jurisdiction being done. So briefly, genocide, there are two aspects to be considered. There was a genocide as a genocide and effects of genocide. So you have been talking about denial and other things. Genocide survivors, victims suffer more than benevolent deniers than the outright deniers. Thank you.
Thank you very much. And I think this comes as a very complete reconceptualization of what we think justice is now in the mind of the victim, being more of not really inquantifiable, or no one was expecting a recourse after all. People were expecting to live. So the whole entire idea of the post genocide was completely, and so I think that rethinking of the justice being what they deserved before they had to go through this is very interesting. Now jumping over to Jean Bosco. just on the same question, and then before now we could get into a particular few questions, because I think we're running out of time, about the expiration date and the whole entire prosecution process in relation to justice served to people, to the victims, after 30 years. When the time elapses from 1 to 30 years, does the magnitude of your persuasion, of your pursuit of justice as a prosecution gets more intact, or it flexes? Does time affect the prosecution efforts? How do you go down to it?
Thank you, Michael. Actually, when I read the topic as it is, the roadmap to combat impunity against the genocide perpetrators, I began pondering, where am I going to start from? And I started reading some stuff, and I came to understand that the roadmap to combat impunity against perpetrators can be traced in a letter dated 29th of September 1994, written by the government of Rwanda to the President of the United Nations Security Council, calling for the earliest possible establishment of the International Criminal Tribunal to try the alleged perpetrators. And this one, I got this letter in the United Nations documents, and I said, wow, this should be the beginning, where the government of Rwanda thought that immediate aftermath of genocide, that there should be an international tribunal to bring to book the perpetrators of the 1994 genocide perpetrated against Tutsi. And it was on 8th, as earlier mentioned by the panelists and even the former prosecutor Bakari Hassan Jero. It was on 8th November 1994. Based on that letter, and when they constituted the ICTR, it was on 8th November 1994, and the resolution 955 that ICTR was established. We all know what ICTR did. Of course, they started with the high-profile cases. 93, they immediately arrested 85. And as earlier, the former chief prosecutor mentioned, 61 were tried to conviction, 14 acquitted, and of course, there were also the others that were still roaming, who were still wanted, whom through the work of the National Public Prosecution Authority in conjunction with the Office of the Prosecutor, we raised, and under 11 bis, Rule 11 bis, we managed to secure referrals of 6 suspects of genocide. And we had a very big challenge because in 2007 and 8, we had through the prosecutor, at the Office of the Prosecutor, we requested the referrals of these, of some cases, including Gatete Jean-Baptiste, also Kanyaruchiga Gaspar, and Yusuf Mnyakazi, but we could not go through because there were some issues which, of course, we came back and dealt with. We enacted some laws, of which the transfer law, we had to table it very well to ensure that once these cases are referred back, the competent court will be the High Court, the High Court Chamber of the International Crimes. So we, all of a sudden, we went back in 2010. Then we secured the first referral case in the names of Zhao Inhindi in 16th of June 2011. So that's where we began. So when we are looking at the impunity, of course we had many fugitives roaming around in Europe, in African cities, as if nothing happened. So we wanted to, although we had good laws, but I will come back because by the time in the 1994 when genocide was perpetrated here, unfortunately we did not have a repressing law to repress the crime of genocide, and we know what that means. And I can say that although we did not have that law in our laws, we had our own criminal law, the Penal Code, which came into force in 1977, 2 years, actually, the Rwanda had ratified the 1975 law, the Genocide Convention, which of 1948, it had been ratified in 1975. But how do you now come in 1977 and you ignore the crime of genocide and you don't put it in the provisions of the Penal Code? So you know what means the legality principle. So this came back to haunt us in 1994. We had almost 120,000 inmates whom we did not have the law to repress. So it came until 30th August 1996 that the first law of its kind repressing the crime of genocide came into existence. And it was 1st September that prosecutions started in Rwanda in 1996. So you can see where we came from. When we are talking of the roadmap to combat impunity, this is where we come from. But again, coming back to what I was telling you about the ICTR, so we can say ICTR did a lot of work. Of course, the prosecution in Rwanda, before the establishment of Gacaca courts in 2002, we had 6,000 cases prosecuted within the space of 6 years. And yet, as I have already mentioned, we had a lot of inmates waiting for trial. We could not have survived as prosecution had it not been the Gacaca courts to be established that, as my colleague Certa mentioned, managed to handle in a space of 10 years close to 2 million cases. So I think you can see where we came from. Although we might not have satisfied the survivors, genocide survivors' needs, because both in International Tribunal for Rwanda, ICTR, and Rwanda also, in some cases, for Rwanda, there are some cases where they gave some damages resulting of course, they had won some damages, but where do you get that, where do you get these damages, the money to pay back? So at the ICTR, they do not even have a provision in their statute that they can give this, at least they can give damages. So it was challenging. So.
Yeah, no, just not even to lose the transition, still on you. You mentioned about fugitives roaming around and so on, and you in additionally being the head of the fugitive tracking unit. What has been your strategies in bringing these people to justice, the fugitives? And do you have some notable successes that you've been able to record for the last few years?
Yes, we do. We do have, because since its inception in 2007, the Genocide Fugitive Tracking Unit within the National Public Prosecution Authority, we have managed to issue 1,149 indictments and arrest warrants, of which 30 people were tried in a domestic jurisdiction where they were found to be living. And of recent, of course, the 30th case is the one in Belgium, who is of course going to appeal. But again, we received some extraditions and referrals from the ICTR of 30 people. This is a very important note, because it signals that one can run justice. You can go to Europe, you can go to any African country, but you will not run away from the long arm of justice. So if we are talking of people who the Rwandan community knows very well, if we are talking about Mugesera, who on one day back in 1992 just declared that Tutsis had to go back to Ethiopia through what he called Oliver Nyabarongo, and I think this man was brought back in 2012. We have many, many others also, but the problem which we have been facing in tracking these people, they always change their identities.
Yeah.
When we say changing their identities and nationalities, this is something, because you lose your identity. We are looking for someone called Kamana, and he's, in the next day, who is a Rwandese, he changes his nationality to a Congolese, and he's called maybe another name. So by the time you go looking for him on the new names, he has completely, even, there is time which is not always on our side,
Yeah.
but there is also this person whose information is not straight coming. There is also, and by the way, change of names did also affect the ICTR in the case of Simeo Shamigo. Simeo Shamigo was the deputy prosecutor in Cyangugu. He worked within the ICTR, and he was on the list of 93 people who was being wanted. He worked close to 7 years, seated in the ICTR, and this man was, he had declared himself within the ICTR registers that he was a Congolese, called now Bahati Weza. How do you now mitigate, or how do you, Simeo Shamigo, now turn to Bahati Weza, a Congolese? These are the same things we are facing in tracking.
And so do you just to that, very interesting. So do you have, how do you address that then? You know, change identity, do you have some counter tactics that you try to, deploy and try to uncover that?
Of course, we rely on information. Information, always information. And how did the Simeo Shamigo, for instance, got identified at the ICTR? It was through a witness who had come, prosecution witness who had come to testify, and he saw his former colleague. I say, oh, how are you, Mr. Simeo Shamigo? Ah, no, I'm not the one. I'm not the one. So that's how he got arrested.
Yeah.
So
information.
Information is key.
Yeah, but also just still talking about witnesses, and it's really a great shift from you, the prosecution, which always mostly on law enforcement, now to me, I liked when you're talking about victim-centeredness, and I think I've noted several speeches you've been, and even your previous intervention. And you've also often talked about, when you minimize that victim in the whole entire process of prosecution, and really get them to the zone of them being witnesses only. What's the effect of that when the victims are looked at as just witnesses and not part of any other process? Where do you locate them? Where do you straight them from this process, and what are the effects anyway when they are viewed as just witnesses?
There is actually a serious effect over that. In the first place, we talk about genocide because you have perpetrators on one hand and the victim on the other hand. So the essence of justice is ensuring that people who committed the genocide are held accountable, and ensuring that the victims of genocide are benefiting from both institutional and legal frameworks in place. When the general perception of the victims, they simply think they serve as pedagogical tools. Here I refer pedagogical tools. Just other communities around the world, other states, stakeholders, professionals may take advantage from the pain and fake the rest. There's no babysitting over here. I'm now talking as someone who's raised the voice of victim. Now, when you look at the proportionality, the tremendous efforts done and highlighted in previous sessions by stakeholders, by the decision makers, by professionals. When you go somewhere in the remote area, or we give a mic, and assuming a genocide victim in the remote area, in the southern part, eastern part, northern part, you ask them, none of them will tell you that the victim is certified. Why the victim is certified? Because all arrangements, mechanisms in place, strategies, allocation of budget, none is reflecting the reality of the victimology on the ground.
Yeah.
So here I'm not denying what has been done. A lot has been done. But to what extent has it been done? I'm saying, yes, the record of ICTR and other international instruments, but to what extent?
Yeah.
We are talking about Gacaca courts. Yes, there is a record, but to what extent? We are talking about the work of national prosecution. Yes, I feel, but to what extent? Yeah. We are talking about the strategies in place for tracking fugitives. How many of them? We are talking about even those who have not been even identified. To what extent? We are talking about international mechanisms. We are talking about international standards. We are talking about national standards. But to what? To the satisfaction of who? If you are to talk about that a victim has been certified, it's not just Prosecutor General is just giving a record of what he did. Minister of Justice, Dr. Manuel, is telling what he did. Prosecutor here from what he did. But who are the beneficiaries of all this?
Yeah.
So I'm saying people who are the stakeholders, I like the topic here, preferred to, it's a roadmap, it's a process, but in this process, in the last 3 decades, a lot has been done, but other things are not yet done, and the only standard and the only witness to testify that they are certified are victims and not stakeholders and not practitioners.
Yeah. No, thank you very much for great intervention. And I think the researchers from Certa Foundation usually have an assignment here, and this is a great idea.
It's a very interesting topic of research.
Yeah, this is a great
very interesting.
This is a great title of our paper, which is justice beyond the law, semicolon. You take notes. From the victim's mind. It would make a great paper, and then we can review it, and then we can share with the men, and but quite a very great, interesting approach. I really like it. And now the last question to Doctor, and I know you've been just in Minnesota for a few months, but I'm obliged to ask a few questions about your role as the head of the Judicial International Corporation. Maybe you might not want to talk so much about your experience within the role already because you don't have so much in that. But what are your plans, or what do you see? And of course, you've been in academia and you've been in prosecution as well in the same unit. What do you see cooperation? We've seen statements on Twitter. Most of the things now in these days are happening on Twitter, and we see back and forth between the government and specific government about we have someone there is a perpetrator, we need some access, we need to locate them, but there's no clarity, there's pool of muscles, and Rwanda will eventually write a statement like, Belgium, we're not happy with this. Where do you see it, and what's the status quo? And do the nations really, as time goes, understand the sensitivity of this and therefore attach more weight to this and really comply and cooperate, or we still have those issues where we have to rely on, God's there, and if they change their mind, let them work with us?
Thank you very much. That's actually interesting. Like you rightly asserted, one of the big challenges that we are facing is lack of cooperation from the international community, from different countries in pursuing, in following up, in investigating, in tracking these fugitives. So you're asking, do countries really understand the importance? Do we have hope for any change? As my colleague was presenting, we have a challenge. There's lack of political will. You just mentioned and gave examples of maybe one of the European countries.
Yeah.
But actually, even before we cross over to Europe, let us
In
see
Africa.
in Africa, yeah, if you look at the number of indictments that have been issued, you find that we have some cooperation, like it was said, from European countries, 30 trials in different European states. But if you look at the African continent, that's where the majority of the indictments have been issued, but we have no reactions,
Yeah.
no responses for those.
Yeah.
So there is a clear lack of political will. And even where there is kind of a political will, there are other challenges connected to the laws. Sometimes they say they cannot prosecute genocide that happened in 1994 because they did not have legislation. So those are legislative challenges.
Yeah.
But there are also other practical challenges that my colleague mentioned. So what do we have to do as the Ministry of Justice? Do we sit there and say we are facing a problem or a challenge of inadequate cooperation? Yes, we have it, we acknowledge, but we don't just sit there.
Yeah.
There are efforts by the government. How do we, if they say we do not have bilateral treaties, how do we initiate these bilateral treaties, multilateral treaties, to see that we secure either extraditions, but if they cannot extradite because of the principle, then then let them prosecute. So how do we attract logatory commissions to come to Rwanda to do the investigations so that we can secure more numbers of fugitives?
Yeah.
Yeah.
No, thank you.
If
No,
I
I'm
may
just
add
listening.
one.
Sure.
Actually, just to remind that the UN Security Council again in Resolution 2150 of 16th April 2014 reminded state parties of the United Nations to always lend their cooperative hand in this case, in these cases of fugitives roaming around, and also reminded some countries which have not signed and ratified the Convention on Genocide to do so, so that they can at least have, they can have the legality, the legal foundation of trying these cases. Dr. Charles is saying to the Director Judiciary, of course, once you have not ratified the convention, then it would become so hard to try domestically. And what we have seen, we have been seeing some countries who actually tried these cases, and they tried them under the false definition. You find them war crimes, torture, although they reach at the sentence, life sentence or 20 years, but we need that at least they can address the issue in its proper context.
Yeah. First of all, I had almost like 5 questions each for you, but the time is ticking there, and some panels in the morning decided to use more time, to share more. We accepted that. But any conclusive remarks, and then we can wrap up, because there's really great discussions happening here. If we had to unpack one by one, we won't finish, but Dr. Charity, you have some conclusive remarks on that.
Thank you very much. If we are to fight this challenge of impunity, we need a multifaceted approach. Just as we had the ICTR, we had the national courts, we had Gacaca courts, but we are having third state prosecution. So I cannot say right now that we just needed this approach for us to curb impunity. We needed all of them to work in a complementary manner.
Yeah.
And as the government of Rwanda, we need to initiate more efforts or to put more effort in the guarantees that we give.
Yeah.
This is really very hopeful. If I can share an example in seconds, I know we are running out of time. We always conduct visits to monitor the guarantees that the government has issued, given to different countries. So when we go to the prisons for these who have been extradited, and we look at the prison conditions, in most of the cases, they do not have complaints. You will find their complaints, we need conjugal rights, which, yes, we They give us, yes, communication fees, but at 2,000 per month is not enough, which means the government is actually adhering and complying to the guarantees. And that has helped us when we present that in different countries or indicate that in our guarantees. We secure extraditions, though it is not yet sufficient, but we are also committed to do that. And to end with one other component, when Tembila was presenting in the morning, she talked about the mandate of the UN mechanism, that is the international criminal, the residue mechanism for international criminal tribunals. So one of its mandate is to facilitate and render assistance to domestic jurisdictions, but under which scope? In investigation, prosecution, and tracking. So as of now, there's an agreement, there's a cooperation framework between the mechanism and the government of Rwanda through the NPPA, and we are going to benefit from the expertise. Though they've closed the cases that they have, but then we need to benefit from their expertise to help us in tracking so that we can counter the challenges that were mentioned. So to close, we need all approaches, we need everyone's participation in order to solve this challenge.
Thank you. Thank you very much. And please, may you clap for the panel. And also to thank you, Jean Bosco. That was really great to have you on the panel and share all these experiences, Ms. Janvier and Dr. Charity. I will have a proposal to Florida that we should, because we didn't finish this, we have a platform called Café Juridique, where we can take this and actually expand on it. And they're actually mostly young people who are interested in criminal law prosecution. And also, before we leave the panel, I would love to really thank Florida and the team. There's actually a lot of work that goes in here. I was reading the journal, which has more than 140 pages, and very young names, very concrete, very substantive enough, proper arguments to the core. And I know how much has to happen. The mentoring, it's a very I welcome everyone to pass by, visit, and share everything with these people. And thank you very much. And thank you very much, JD. You may assume your role again. Thank you.
And thank you so much for saving me from not standing here before you finish. Another round of applause to this panel. You did great. I want to thank everyone whose participation has made this event a success from the morning until now. We are coming to the end of our event, and I simply wanted to make sure that I see young people learning and confirming that they have learned, especially those of you from academia. There is no excuse. We had the experts. We had people who lived the experiences. This was different from watching a movie. This was different from reading a book. You just interacted with people who lived these experiences, and they were sharing it with passion and excitement. So I do hope that everybody who was in this room learned something, and we hope that it is contributing to the overall goal that we had during the preparation of this conference. With that being said, allow me to finally invite Ms. Kabasinga Florida, the founder and executive director of Certa Foundation, to come for her closing remarks. And thank you so much for cooperating. Don't wait for me to come back here. It's my last statement. Thank you so much for trusting me and for allowing me to moderate this event. I appreciate it.
Thank you, JD. Before I make my closing remarks, I would like to make just a few statements about what my fellow counsel, Maitre Janvier Bayingana, has said in the last panel. To be honest, it's very hard to imagine that there's a situation where victims will ever feel satisfied with justice. How much punishment can you give somebody that can equal the lives that were taken in this country? There is never going to be enough justice. All we can do is try our best, and I think everybody does try their best. So I know where you're coming from, because you too are a survivor, but just know that we understand the pain, and we know there's never going to be enough for the victims, and it's completely understandable. There are so many families that were completely wiped out in 1994. How can you restore what was lost? It is important that we never forget and that we understand where the victims are coming from. On that note, mine in closing is just a thank you to everyone who was involved. I think I am not overstating it when I tell you that I work with the most amazing team that I know of. The most hardworking, the smartest, the most passionate group of lawyers and young people that I've ever worked with. I'm very, very proud of you for pulling this off, for pulling off the journal, for the documentary. Please, can you stand up for recognition? Benita, Lydia, everybody, please. Everybody at the Center for Law and Innovation and the Center for Justice and Advocacy, you guys are amazing. Thank you for your hard work. I'd like to thank the Rwanda Bar Association for having partnered with us. Mr. Batonier, thank you for your support. You are chairman of our board, and your support speaks volumes. You take your role very seriously, so we are very grateful. To the council members who've been with us since morning, we are very grateful for your participation in this and other events of the foundation. Events Factory, we thank you so much for your support. They are the most professional people that you can work with when it comes to preparing conferences. What can I say to my friends from the ICTR? Charles and Tembile. I am so, and Justice Jallo, who sent his remarks. I cannot thank you enough. Every time I tell you that there's something going on, all my friends at the tribunal jump and come to participate in events, and I'm so grateful for that. And I know a lot of other colleagues are always wondering why I'm not inviting them, but there will come a time. These conversations are just starting, and you'll hear from them as well. To the contributors to the journal, thank you very much. Your scholarly writings are going to contribute to the discourse around the genocide against the Tutsi that happened in this country. I'm grateful for the support from the public sector, for our guest of honor, the Honorable Chief Justice, who showed up this morning and supported us, and the Minister of Justice, and the National Public Prosecution Authority's representatives, among others. Thank you, everyone. I hope you walk away with some lessons, and these conversations will continue because we always aim to remember. This is only 30 years, but we'll continue to remember from generation to generation. Thank you so much, and have a good evening. Thank you to the MC and the panelists too. So there is coffee outside, I forgot to announce, but you can have something to bite and drink before you go.